Your Lordship, I'm very sorry about that. I don't know what happened. I'm using my phone now.
Okay, not to worry. It's these things happen, and it implies absolutely no default on your part or on your team's part. Anyway, look, we're up and going now. If we can, I can see you well. So if you wouldn't mind continuing on the phone while they try and work out a solution to let you join on your computer. Right, now you will have seen my proposed timetable. We've really got to get a move on today. The first item on the agenda is to complete the cross-examination of Mr. Malik. And so I'd like that to proceed straight away and within the time that I've set. So over to you, Mr. Matu.
Thank you, my lord. Mr. Malik, prior to your first witness statement, you would agree that there's not a single email, note, or document offered by you which concerns any issues in these proceedings, correct?
I'm very sorry to interrupt. I'm getting real feedback. I don't know if anyone else is.
I'm getting a bit of feedback. Is there anything we can do about that?
Could everybody mute apart from those speaking, please, and then we can see.
Let's see. Put the question again, please, Mr. Matu.
Mr. Malik, prior to your first witness statement, do you agree that there's not a single email, note, or document authored by you which concerns any issues in these proceedings, correct?
Yeah, I think so. Yes, correct.
And in light of your inaction after 3rd February 2020, you will agree with me that you didn't perform your duties as a director of compliance and risk as expected from someone who has been a senior compliance officer in DFSA regulated companies for over 11 years, correct?
What I didn't do is I didn't fully investigate this after the 3rd of February, which I should have in more detail, yes.
Mr. Malik, if Dr. Ahmadi knew about Tabarak's involvement in the BTC transaction prior to 3rd February 2020, you would agree that as the head of compliance, risk, and AML, you would expect Dr. Ahmadi to inform you about this transaction, correct?
Yes, correct.
Further, assuming Dr. Ahmadi knew about this BTC transaction and did not do anything to stop it, in that scenario, you would agree that Dr. Ahmadi would be in violation of Tabarak's due diligence policies and account opening procedures for allowing the BTC transaction to proceed at Tabarak's offices, correct?
If he knew about it, he should have told me, definitely. Yeah.
And would it have been violation of Tabarak's due diligence policies if he had agreed to proceed without at that stage?
If he had agreed to provide a service, you mean?
Yes.
Yeah. You're not supposed to provide a service.
So from your experience, is it possible at Tabarak for a CEO of the company to overrule these due diligence and account opening policies?
Not when it comes to onboarding a client. No, not allowed.
Have you ever found anyone in breach of these policies?
Not that I'm aware of, no.
Do you agree that you failed to carry out a proper audit of all the emails of Tabarak employees concerning the BTC transaction from compliance and risk management perspective?
You mean after the 3rd?
Yes, after the 3rd.
Yeah. Well, as I mentioned beforehand, IT tried to get the emails, and it was difficult for them to get them. But I did instruct HR and IT to do this. So yeah.
And do you agree that had you carried out a proper audit of Tabarak email accounts of Dr. Ahmadi, Ms. Zaviolova, Mr. Turner, and Mr. Kadir, you would have gathered enough information to understand the BTC transaction, correct?
Yeah, afterwards, yeah.
In respect, in your testimony on day 6, you stated that there may have been a board meeting after the incident of 3rd February 2020, correct?
Yeah, there's many board meetings. You have to have a certain amount of board meetings per year.
Do you normally get a copy of the Tabarak board meeting minutes?
No, they're with HR.
Presumably, if there was a board meeting on concerning the incident of 3rd February 2020, there would have been a board meeting minute of that meeting, correct?
As mentioned previously, she's the company secretary listed with the DIFC, so she would have these minutes and they're provided to her, and she writes up the minutes and she holds them in the files. Yes.
And after concluding the investigation on Mr. Turner's role in the Bitcoin transaction of 3rd February 2020, you agreed that you did not give any presentation or training to TABARAK employees to ensure that what happened on 3rd of February 2020 never happens again, correct?
Yeah, definitely.
And in respect of the Wolfsburg questionnaire, when did you discover your signature was forged in Wolfsburg?
No, that's not my signature. So it's not forged. It's not my signature.
I'm saying, when did you discover that? When did you find out?
When these proceedings started afterwards, way after.
So sometime in 2021 or sometime in 2020?
21.
So any month in particular, if you remember, if you can recall?
No, I was shown all this by the lawyers, etc.
But you never wrote any email about this to Dr. Ahmadi or any other person in TABARAK, correct?
Once I found out, you mean?
Yes.
Yeah, no. I'd spoken to Dr. Mahdi about it.
And you didn't inform the board formally about this, did you?
No.
So you agree you didn't take any concrete action regarding this after finding out about this issue?
As I mentioned previously last week, this all happened after the 3rd of February. In hindsight, things should have been done better. I understand that. But when it comes to the involvement and what I knew about prior to the 3rd of February, I really didn't know anything. But afterwards, yes, I should have done more. I should have maybe put more in evidence in terms of writing emails and trying to find out what happened, etc. But this is something which has never happened, and it's just really difficult. It was difficult, and I should have done more. Yes, afterwards, definitely.
You've got about 2 minutes, Mr. Makhloud, to complete this.
My lord, in accordance with the directions, I have no further questions. Thank you very much, Mr. Aziz.
Thank you very much for your cooperation.
Thank you.
Re-examination, please.
Yes, Mr. Malik, very quickly, can I ask you to turn up, please?
Sorry?
Can I ask you to turn up page 8, section 8 and 628?
Okay.
Could you give the reference again? Sorry, Ms. Ahmed.
Yes, 8-628.
Yes, I have that.
Thank you very much.
Can you tell the court what this is, please?
These are standard due diligence documents which I prepare before I even think about registering a client to be onboarded.
And would Mr. Thurn be familiar with these documents?
Yeah, he's seen these documents, but they're for my reference, really.
Right, can we turn to 8-633, please?
Yes.
Is this a standard TABARAK client classification form that Mr. Thurn would have been familiar with?
Correct.
8-645.
Yes,
The same question there.
that's correct.
8-655, please.
Yes,
Can you tell us what this is?
this is a standard account opening agreement.
And we see at the top there the title account open agreement. Is that title usually used for these agreements?
Yes.
Thank you, Your Lordship. I'm grateful. I don't have any further questions.
Thank you very much. So we now have Mr. Turner to be called by the second defendant.
Thank you.
Now, Mr. Makhloud, all I want you to do to begin with is just to elicit his name and his address.
Sure.
Then I'll deal with the oath or the affirmation, and then you can take him to the signature and so on. Okay?
Yes, my lord.
Right?
Ms. Turner, can you give us your full name and your address, please?
My name is Christian Franz Turner. I'm living in Dubai, Roda Al Mourouj, Residences, Building Gardenia, Suite 902.
Good afternoon, Mr. Turner. Judge speaking.
Good morning.
You may have been observing some or all of these proceedings, and you'll know that every witness is required either to give a religious oath or a secular affirmation that his evidence is true. Which would you prefer, a religious oath or a secular affirmation? They are of equal standing so far as the court is concerned.
A secular affirmation, please.
Right. Just listen carefully and answer this question. Do you sincerely, solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I will do.
Thank you very much. Yes, Mr. Matthew.
Mr. Turner, can I take you to your fourth witness statement, which is at 6105?
Yes.
Is this your witness statement?
This is my witness statement, yes.
And can I take you to the last page of the witness statement, which is at 6117?
Yes.
Is that your signature?
This is my signature.
And can I now take you to your eighth witness statement, which is at 751?
Yes.
And is this your witness statement as well?
Correct. This is my witness statement.
And if I take you to the last page of this witness statement, the eighth witness statement, 7, which is at 762, is that your signature?
Sorry, 762. I have it on the screen now because it's not on this. Yes, it's my signature.
Thank you, Mr. Turner.
Well, I think you normally ask him also to confirm.
Sorry, are all the facts and all the?
Yes.
Sorry, my lord.
Sorry.
It's quite all right. Towards the end of his witness statement, he will confirm that to the best of his knowledge and belief, what he says in his witness statement is true. Is that right, Mr. Turner?
That's correct, yes.
Good. Well, thank you very much.
Thank you, my lord.
We can move to cross-examination, and we begin with Ms. Stewart.
Mr. Turner, first of all, now we know that TABARAK and Pecunio, they signed a letter of intent in 2018 in relation to the purchase of by Pecunio of 20% of TABARAK shares. What was it that Pecunio did at the time the letter of intent was signed? What was its business?
The business of Pecunio was a blockchain company which had placed on the market a model where they are using a gold coin, which is 100% asset backed by physical gold.
Okay, and was that somehow, so was that a crypto asset linked to a gold coin?
It was a digital asset. As I said, it's a gold coin, 100% asset backed by physical gold. And when you state now already crypto and digital asset, crypto, we understand cryptocurrencies. Digital assets, we understand utility bills or security tokens. And this was definitely something in a security token, which means it's not a cryptocurrency.
Right.
It is a digital asset, digitalized physical asset.
Right. So in your view, a crypto asset is not a subset of a digital asset. Is that correct?
Can you explain, please, what you mean with this?
Okay. A crypto asset is not a type of digital asset. Is that what you're saying?
This is not correct. It is a type of digital asset, but in the crypto world, it is different. How to say? Information on cryptocurrencies, which are on exchanges by chart, and then you have digital assets, which is also in the crypto world digitalized, but it's not named crypto. It's a blockchain related product, which is digitalized value of a physical asset.
Okay, but a crypto asset or a cryptocurrency doesn't necessarily have to be on an exchange, does it? It could just be sitting on the blockchain in someone's wallet, basically.
Could be.
Okay. So, right. Now, tell me, what was your role at Pecunio? I think I've seen the title COO.
Yes. I was setting up as an angel investor, one of the first investors at Pecunio. And as I had at this time a partner with me, Mr. Erich Ramsel, and he asked me to take some role in the company to set up organization. Organization means with staff, office, and so on. And this was the help what I did at this time. So concrete, I was an angel investor who gave with my partner money to Pecunio to start the business.
And that gold-backed coin that you were talking about, is that the coin that also Pecunio tried to or did launch together with TABARAK?
That's not correct. It was launched before TABARAK. TABARAK should only provide the gold, the so-called physical asset, the gold bars or the gold in a vault, which has to be, back up the Pecunio gold coin.
Okay, but in order to provide that, TABARAK would have to understand how the underlying mechanism worked for the financial instrument.
Yes.
Okay. Now, if we go to 8710, please, Mr. Turner.
Just a second, it's on the screen loading. Yeah.
No problem.
8710 or it's what?
Yes.
8710.
Correct.
Yes. Yes.
Now, this is a page that I brought to Dr. Amadi's attention when I cross-examined him. And in particular, I highlighted the words issued and handled by TABARAK Investment Bank, which you can see small words just beneath Pecunio gold coin. Now, I checked the web page again yesterday, and those words issued and handled by TABARAK Investment Bank had disappeared since I cross-examined. Could you explain what do you know about why that might have happened, if anything?
Yes. So first of all, you have to understand all was based on a so-called agreement, on a share deal agreement, where Pecunio should have paid the agreed amount, which was signed. And related to this, there was already produced a pitch deck. It's called pitch deck. Pitch deck means some explanations as you have it already here, which should be marketed then when everything is ready. So as Pecunio did not pay the agreed share value, so this came never into force. This you have to understand.
Okay, and So going back to who was it who inserted those words initially, which say issued and handled by TABARAK Investment Bank?
I guess this was Pecunio Marketing, but I don't know. It was produced, we got known of this, everything was prepared, but as I said, it came never into force.
Okay, so you've been an advisor for Pecunio. Are you saying that you never saw this?
Advisor for investors, yeah, to bring money, to raise money from the capital, as it is my profession on financial industry, but not on technical issues, not on how it works and whatever it is.
So, but TABARAK is, if we go to page 704, TABARAK is still, when I checked the web yesterday, the web page, TABARAK's still listed as a partner of Pecunio. So is it the case that TABARAK was or is a partner of Pecunio?
First of all, it's not a partner of Pecunio. It was several times mentioned to, I guess, Dr. Berger, the owner and CEO of Pecunio, that the website has to be shut down or adjusted. And there must be also a letter at TABARAK where we requested this, because the share deal was not executed. Also from my side, as I saw now during these investigations, that it is still on, because I didn't take care on this. I told him also, we have a letter from your side. I was in contact with Dr. Berger, and he apologized because of some big issues, because he's working now as a lawyer, because he studied also law in Austria, and he forgot and he did not see anything, because Pecunio is only like a sleeping, whatever.
So you, after Dr. Ahmadi was cross-examined, you ensured that the wording handled and issued by TABARAK Bank was removed, correct?
Sorry, repeat again. I assured what?
After you heard that me cross-examining Dr. Ahmadi about the words handled and issued by TABARAK Investment Bank, you asked Pecunio to remove that wording.
Correct, yes. As it was already agreed long time before, and
Yes,
as there is an existing letter from Pecunio, they will do it.
But the TABARAK, the mention of TABARAK as being a partner wasn't removed. Okay.
I don't know. I mean, this is not my task.
Right. Now, in that case, can you just clarify one thing? Can we go to 852? 852.
Yeah.
Now, Dr. Ahmadi maintains that he didn't know about this article at the time and that you weren't authorized to make, to provide the comments that you did in that article. And that's an article in which you call yourself head of digital asset management. Is Dr. Ahmadi correct?
So here also to inform you, this was brought to knowledge of TABARAK, Dr. Ahmadi, and also from my side, because I became then a consultant and later on the director of investments of TABARAK. And we had several issues which on the terminology has to be changed.
My question is very straightforward, Mr. Turner. At the time this went live, this article, was Dr. Ahmadi aware of this article?
I guess he was, yes.
Well, was he or wasn't he? Did you talk to him about it?
I cannot tell you more. I guess he was.
You would,
Right.
you
This
would,
is
wait,
as I recall. I cannot say if he was or if he was not. I guess he was.
well, can we put it this way? You would have expected him to be aware of it.
Yes.
Is that right?
Yes, correct. Correct, Your Honor.
And did you talk to him about it at the time?
He was talking to me later on after this. So as I said, I guess he's aware of all of this, that something has to be changed. And I guess when I recall it correctly, he made also corrections to these articles or to this, what was launched or what was sent by Pecunio.
Oh, okay. So what appears on Pecunio's website then, that's the article that he actually made some adjustments to, made some amendments to.
I don't think so. I think this was what they did by themselves then, because there were some arguments, as I recall, from Dr. Amadi with Dr. Berger.
Okay, but you're saying that Dr. Ahmadi did have an input into the wording of this article. Is that correct?
That's correct. They had discussions. But as I stated before, as the deal was then not came into force, it was clearly the task to remove everything because the share deal was not executed.
Right. Can I take you to 8661?
Sorry, it's small like this. Okay.
Sorry, it's really small.
664, yeah?
No,
not 4.
8661, Mr. Turner.
661, 8661, yes.
Now it's really small wording, but this is an extract from a printout from your OCS company. So that's OCS International Finance Limited. Yeah, this is from the web. And it states that you were an executive director of TABARAK from January 2019 to June 2020. And then it says investment and cryptocurrency department.
Yes.
So you're the SEO of this company, this OCS company. So you approved this wording, did you?
I am the CEO of the company, that's correct, of OCS. And this was the statement, yes.
So it is the case that TABARAK had a cryptocurrency department, even if that was just you and perhaps Ms. Saviolova, while you were at TABARAK, yes?
So Ms. Saviolova was not in the cryptocurrency department, or whenever, however you want to call it.
Okay.
But it was definitely one part that, because of the new age, that TABARAK should become a part in this digital asset crypto world to provide services for the client. That's correct.
So digital assets there, that would include Bitcoin.
Bitcoin, as it is a value on the market, and when a client is having Bitcoins and he wants to give to TABARAK for arranging custodian service or something, then yes, it is an asset.
Okay, and it's the case that during a meeting that you had on the 16th of December, you did say to Mr. Al-Ali that TABARAK provided crypto custodial services.
Can I have the page Can I have when?
This
please?
was evidence that came out in cross-examination, and it's also included in Mr. Al-Ali's witness statement. I'm simply putting the question to you.
Good. Can you repeat the question, please?
During that meeting on the 16th of December, which was during that meeting on the 16th of December, you did say that TABARAK had provided custodial services in relation to crypto, and that it would do. It was happy to explore doing that with HUOBI. Words to that effect.
Well, I was going to say that's evidence. It's not in the witness statements that you would do.
Miss Ahmed, I can take you to the transcript. I didn't interrupt you in your 9 hours of cross-examination. So
You also the statements. It's not in any of the witness statements. I'm just clarifying that.
Oh, all right. Well, I take it from Ms. Stewart that it's in the transcript, and we'll proceed on that basis.
Thank you.
Good. I will answer. It was definitely discussions regarding so-called cryptocurrencies or digital assets and services which can be arranged by TABARAK, but I cannot recall clearly when you asked me what was the wording or what was the content.
No, quite. It was some time ago, but it was. That's why I used the phrase "words to that effect." But thank you.
Yeah.
Now, you'll be aware that the court's attention has been brought to numerous emails into which Dr. Ahmadi and Mr. Kadir Khan were copied into, which made it clear that you were involving TABARAK in a Bitcoin transaction. Yes?
I'm sorry to say not. I guess you shouldn't use another wording, because not I involved TABARAK in something. There was a prospect, or let's say a interested party of buyer, interested party of seller of something, and we are providing services which are ranging of custodian service, and also they wanted to onboard with TABARAK. So not I did, as you want to mention, the clients came by themselves to ask for services from TABARAK.
And you said that TABARAK could provide those types of services.
It was part of my job to onboard clients and to provide services so that TABARAK earns money and also me are earning money. Yes.
Yeah, absolutely. And would it be fair to say that Dr. Ahmadi or nobody at TABARAK ever prohibited you from involving TABARAK in any type of crypto-related activity? There was no prohibition.
I kindly ask you to replace the word crypto for digital asset. There was not crypto, it was digital assets, please.
Okay, but you've accepted.
And yes, TABARAK is interested and was at this time on the way to set up a so-called digital asset part as a service for clients.
And you have accepted, as I understand, that digital asset includes Bitcoin.
Yes, because Bitcoin, as I told you already, is a part of a digital asset. Yes.
Yes, thank you. Sorry, there's been some dispute in these proceedings over what digital asset actually means. So.
Yeah, it was very funny to follow what happened until now when somebody or people are explaining they don't know what digital assets are. But fine, in this world as it is now, I guess everybody knows.
Thank you. Quite. And so, right. So when when on the 16th of December, when Mr. Al-Ali visited Tabarak offices, visited you and had the meeting, would it be, he explained during that meeting that the buyer wanted the Bitcoin and the buyer's payment to be exchanged at the same time, but that wasn't how HUOBI did things, and that HUOBI wouldn't transfer the Bitcoin to the buyer without payment, yes?
Here, I hope you allow me to state a little bit more words. First of all, a lot of those meetings were, and on this day when HUOBI was in, there was discussed, as I recall, some of the procedures they wanted to have, but also there were then discussions with the buyer on these procedures, but honestly, to recall exactly, I'm
okay. But the
difficult.
buyer attended that first meeting, that first introductory meeting. Mr. Al-Ali was there. You were there. Miss Avialova was there, and it was explained that the buyer didn't want to pay for the Bitcoin in advance, and Mr. Al-Ali didn't want to transfer the Bitcoin until he was assured of payment. Correct?
I guess this is correct, yes.
Thank you. And that was why he was coming to you, Mr. Al-Ali, because he basically wanted Tabarak to act as a trusted third party, yes, to help facilitate the deal.
It's also, I mean, yeah, when you state this way, they wanted to become a client of TABARAK, and they wanted to have the services of TABARAK. That's correct.
And Mr. Al-Ali made it clear that he wanted TABARAK to act as an intermediary, a trusted intermediary, to make sure that this deal could happen.
Here I have to tell you that he wanted to have a transaction on neutral ground, as they did not pay until this time.
No, my question,
account openings.
Let the witness finish, please. Go on, Mr. Turner.
As they did not pay until now, and it was only discussions, and there were several changes. I guess it was 3 different versions until this time what the buyer and the seller agreed to themselves. And but when you ask me about Mr. Al-Ali and HUOBI, this was the beginning what they wanted to have. But finally, then the buyer did not agree to this.
But the purpose of coming to TABARAK was to ensure that TABARAK came up with a process which would provide for no transfer of the Bitcoin to the buyer until payment had been received.
I'm sorry, Mrs. Stewart, not TABARAK came to this, the buyer and the seller. And in this case, it was the buyer who wanted to have this procedure, but it did not come into force because the buyer did not accept. It's not TABARAK's, it's not my decision. It's the decision of the buyer and the seller, Mrs. Stewart.
Right. So you're not accepting.
And one more thing, just, Your Honor, if I'm allowed to. As I said, they wanted to have on neutral ground. At this stage, we were not. At this, what was coming after this, and I guess it will be in questions, yeah. But it was since 1 year there was a back and forth with the buyer on something, and also at this time I was very wondering because HUOBI was known to Dr. Ahmadi, especially in the person of Sultan bin Kasham. And also, Rudolf and the buyer was known to Dr. Ahmadi. So, but they, as I and my job is I was installed to listen to this party and to find for both ways some workable agreement
Yes,
for the TABARAK.
exactly.
This was my job. Yeah.
Exactly, thank you. And the purpose of your involvement was to come up with a process to ensure that in
Not
relation
me.
to the transaction, TABARAK.
I'm sorry, it was not me. It was the TABARAK. And there, my job was that these two parties find a way to have a deal.
Yes.
And finally, then, to become client of the TABARAK.
Thank you.
Yes.
So what happened in that first meeting was that the issue was discussed, namely that the buyer wanted one thing, the seller wanted another thing, and you agreed that you would provide details of your proposed process, of TABARAK's proposed process, in due course. So that correct?
No, not correct. First of all, not the TABARAKs. Then when you please specify first meeting with HUOBI or with whom?
This is the meeting I've been talking about on the 16th of
Good.
December.
So it's not the TABARAKs. It was placed by HUOBI what they wanted to have. Then it was issued to the buyer. This it is. It's not the TABARAK. It was the clear situation that HUOBI wanted to have this procedure. But it was not from the TABARAK. It was not agreed, nothing.
Well, I'm going to suggest to you that all that happened, or simply HUOBI came to you and said, we have this issue, we want to make this deal work. Please come up with a process to ensure that the Bitcoin isn't transferred to the buyer before payment was made for the Bitcoin. And your job was to come up with that process, correct?
It was not my job to come with the process. It was the job that I am mediating between these two parties, how they want to do the deal. But it was not my decision and it was not TABARAK's decision. It was the decision of the parties.
And we saw in 3 what are called deal structure emails.
Yes.
So we have that on the 16th of December, on the 20th of December, and on the 19th of January. We have your detailed proposals for how the structure should work, how the process should work.
Yes. This was agreed between the parties, correct.
No, these were your detailed proposals.
Not my detailed, it was this what the parties agreed. Once again, Mrs. Stewart, it was not my decision. And you can ask 100 times, it will be the same answer.
Now, it's the case, isn't it, that you always represented to HUOBI that Navicon and Mr. Morozov were TABARAK's clients, didn't you?
No.
Okay, right. Can we go to 889? This says, we know this email well.
Just a second, just a second.
Oh, I'm so sorry.
Yeah. Okay. Sorry, I have it. Thank you.
Partner 1, Navicon and Evgeny Morozov are running already accounts with us. So
Mrs. Stewart, can you please read the entry of the email, please, before you go to this second, and don't do something out of the content. Go to the entry, please.
Mr. Turner, Mr. Turner, please.
This could work.
Mr. Turner,
Good
please.
work.
Mr. Turner, please listen to me. I'm the referee here in a sense,
I'm sorry. Yeah.
and I'm here to ensure that the questions are relevant and fair. And
Yeah.
if it arises that I have some misgivings about any question, I will intervene. So let me
Okay, I
assure you,
apologize, but
that's
as
all
I
right.
follow, I
Now,
apologize because yeah.
It's quite all right. Now, so Ms. Stewart, would you like just to remind him, as he wants you to, of the words "as informed and agreed" and so on before we get to partner one? This is his email, and it's addressed to Evgeny, and
Yes.
we see that it says, "as informed and agreed during today's meeting, we herewith place the way how the business between you two partners could work." And then we get to the part that Mr. Stewart wanted to draw your attention to, partner one, Navicon and Evgeny Morozov are running already accounts with us.
And I suggest to you, Mr. Turner, that you were there saying that Navicon and Mr. Morozov were already clients of TABARAK.
Not correct.
And then in the next line, you say HUOBI should run an account with us.
Correct. Yeah, I said, or I stated here. Yeah.
Well, I'll be asking the judge to draw his own conclusions as to what that actually represented. Now, so are you saying that you didn't represent, or you never understood that either Navicon or Mr. Morozov were clients of TABARAK?
What is the question? I did not understand.
Sorry. Okay. Did you understand at the time that Navicon was a client of TABARAK's?
No, but they wanted to become a client of TABARAK desperately.
Right. And what about Mr. Morozov? Was he, to the best of your knowledge, ever a client of TABARAK?
No, also he, because this was the same. They wanted to have a company account and he wanted to have an individual account. That's why also 2 invoices from TABARAK was issued for payment of account opening fees, individual and company agreement.
Right, can I take you, so you're saying that neither Navicon or Mr. Morozov ever became a client of TABARAK? Is that my understanding?
At this stage, yes.
Correct?
After this, I cannot say anything when I was not anymore with TABARAK, but
No,
at this
course.
stage, they were not clients, yes.
Right. Right, can I take you to 6108? First of all, at 19B,
yeah.
And if we go over the page, if you just read 19B,
Yeah.
we have over the page, so the first paragraph of 6109, you'll see 2 references to the Navicon SRO account with the first defendant.
Yeah.
Yeah.
And in fact, the second reference is says Navicon's SRO's client account.
Yeah.
Because Navicon did have a client account.
No, just to inform you about how the procedure works when there is an account agreement which has to be executed, then there will be given so-called reference codes. Because in DIFC, as we are not we're acting like a retail bank and we have no central bank, we are acting with outside of DIFC retail banks, and so we have to give in the reference code. And reference codes means then they transfer to TABARAK account in reference to internal to their account. And that's why it was already set up a so-called reference code, because they wanted to become, and I guess invoices were already issued, 2 times 100,000 dirhams.
So you refer to Navicon's client account, even though they weren't a client, as I understand to be your evidence.
They want to become client, and therefore there was issued a reference code and an invoice to be paid. And also in this, because all was future based on for the deal, there was already set up a reference code when they sent in money to the account, so that it is correctly then for the bookkeeping and for the payment department visible who is the reference and to whom the funds belong.
Right, can you go to 6111? If you scroll down a few pages, you'll see that. And in particular, paragraph 32.
6111.
Yeah.
Okay.
Yeah. Paragraph 32?
Yes.
Yeah.
And this is when you came back from lunch.
Yes.
On the 3rd of February. And you say, ask Mr. Morozov about the funds because no funds had arrived in Navicon SRO client account with the first defendant.
Yes.
And then further down, you talk about funds being sent to SRO's client account.
Okay.
The point being is, yet again, you're referring to the Navicon client account.
Mr. Morozov several times stated during the lunch that the funds are already transferred. Yeah, wait, I give you the answer. And here,
you don't have the question yet. You don't have the question yet. The point is,
put the question, please.
Yet again, you are saying that Navicon had a client account with TABARAK, aren't you?
No, it's in brackets, and he had not transferred until this time the funds to the account. But an account internally was reserved for them.
Well, it was called a client
with
account.
a reference code, yes. But the same we had for HUOBI.
Right, can I take you to your memory minutes as well? These were the memory minutes that were provided on the 12th of February to the Dubai police, and we'll find those at 5:20.
Sorry.
So that's 5:20. That's the reference.
8/5/20.
8/5/20. Okay.
I have it on the screen. Yes. What? Is it now? 8? Can I have it? Memory of minutes, case Bitcoin deal. Yeah. It's okay. It's on the screen. Yes, please.
So we can see in what's called the preamble.
Yeah.
If you scan through that paragraph quickly, you'll see that it says, and this is what you represented to the Dubai police, yes? This is what you said to the Dubai police. This entity was supposed to send AED to Navicon account with Tabarak.
Yeah.
And then, if we go, for example, to page 523.
Yes.
There are a number of bullet points there. And in the last bullet point, it says Mr. Morozov did not provide the agreed and mandatory transfer. He just stated the money is on its way, but money never showed up at Tabarak accounts of Navicon.
Correct. Yes.
So again, you were representing to the Dubai police that Navicon were clients of Tabarak.
No, Ms. Stewart, I want to explain you again. We prepared for Navicon and for Mr. Morozov and for HUOBI so-called accounts. They are related to a reference code. And this is necessary because otherwise they have no possibility to transfer funds. And also it's not possible then, when they are clients, to transfer funds to HUOBI. But this means not that they have accounts, because the one specific issue, nobody of these two, by promising they have transferred and so on, have paid the funds for account opening. None of these two parties. But the accounts are prepared, were in place, but nothing happened.
So, now you're familiar with the concept of a correspondent bank, aren't you? Because you would be, because you filled in and signed the Wolfsburg questionnaire that we've seen in these proceedings.
I'm familiar with a correspondent account, yes.
So you'll appreciate that the correspondent bank effectively acts as the correspondent's agent or its conduit, and so it'll execute and process payments for the correspondent's customers. Is that an accurate summary of what a correspondent bank does?
A correspondent bank acts as an intermediary bank between two financial institutions to provide in a specific currency funds to be forwarded to an account, yes.
So let's say that Tabarak or Tabarak's bank, for example, Norbank, had a correspondent bank in Europe, yeah?
Correct, yes.
And let's say a third party pays a sum into the European correspondent bank, whoever that may be. It would be correct, would it not, that that payment in at the European end would be very quickly credited to Tabarak's local bank, the local bank that's a correspondent with the European bank, correct?
That's correct. It's depending the hours, which currency it is. But yeah, you are correct. Yes.
And that could be within an hour or so, usually.
It depends on the time, it depends on the currency, and it depends on the banks involved. Yes.
But generally, assuming markets are open, in principle, assuming all the relevant markets are open, in principle, if, for example, it was euros to dirhams, let's say, that should hit once the euros have been deposited in the European correspondent bank. That should show up in Tabarak's bank within the hour or so?
As I said, depending on the time when they do it. When they do it before 11 o'clock or 11:30 Dubai time, it should be quick. But I cannot confirm 1 hour or so. If it's done in the afternoon, it could take up to 24 or even 48 hours. Because then it's a so-called cutoff time is not anymore due. And then it's depending on the internals of the banks involved.
Right. Now, if we go to your email of the 19th of January, and that's at 8:421.
Just a second. 8:4. Yep. Yes. You mean the email final procedure to start business?
Yes.
Yes, I have it in front of mine.
And you say, after reviewing all of past and history and discussions, this is the procedure we would be able to satisfy all involved parties. And then at the end, you ask if the parties agree to the procedure that you set out, yes?
Yes. It's not me to set out, it was the final decision between the two parties, which was stated in this email.
Well, I think we're going to disagree on who suggested this, but we've been there already, so I won't go there again. Now, what you say here is, I'm getting a bit of feedback. I don't know if someone's...
Sorry?
It was just a little bit of feedback. Just carry on. Let's hope that it clears away, Ms. Stewart.
Now, you say here that if Evgeny has placed verified funds with us at correspondent bank in Europe, and he and a partner also verified funds here in the UAE with 3 major banks, close to 50 million AED. Now, I suggest here that you're informing HUOBI of 3 things. 1, that Tabarak has a correspondent bank in Europe. Correct?
No.
Okay, so what does the correspondent bank refer to?
This is the procedure what was agreed between the two parties.
Yes, but but who?
We can provide them through Norbank a correspondent bank account, not our Tabarak, the bank account, a correspondent bank which is forwarding the funds what Mr. Morozov, Navarcon will transfer to an account of Tabarak, which is related by the reference code to the party.
Okay, so are you saying therefore that the correspondent bank in fact refers to a correspondent bank of Norbank?
Mrs. Stewart, again, this was what was agreed finally between the two parties.
No, I'm asking you a question. You wrote this email. You must know, given that you wrote this email, what correspondent bank refers to. Does it or does it not refer to a correspondent bank of Norbank?
Correct, yes.
It does?
Yes.
Thank you.
Fine.
Right. You're also confirming here that Tabarak has verified that the buyer has placed funds at that correspondent bank in Europe, aren't you?
No, I'm not doing this. It is the procedure which was agreed, and this should happen.
So you're saying that this doesn't say that Tabarak has verified those funds at a correspondent bank?
No. They
So
showed
what
to
does it
them.
say?
May I answer here? They showed to each other. Mr. Morozov showed to HUOBI bank statements from UniCredit Bank Bulgaria, showing, I guess, something around 50 million or so. And also they stated, and as I recall, they even wanted to try to do deals by themselves. They showed to HUOBI funds here in UAE from UAE account.
That never happened, Mr. Turner. The point is that you.
Yeah, but this is a
No,
procedure.
Mr. Turner, Mr. Turner, now just listen
Yeah.
to me. You don't do yourself any credit by losing your patience with this cross-examination. I know it's
Okay.
a very stressful process. I understand that completely. But just stay calm, let the tone
Good.
come down a bit, and I'll
Yeah.
make sure that things are fair. Now, Miss Stewart, do you want
I'll
to
put
put
it.
the
Yes, I'll
question
put
there?
it. I'll put it very simply. In this email, you represented to HUOBI, you informed HUOBI that you had verified that the buyer had placed funds with TABARAK at Norbank's correspondent bank in Europe. You checked that. Yes or
That's
no?
No, that's not correct. It was the
And
will of the both parties, and this was the procedure, which should be a final procedure, which should be executed.
Okay.
And you also informed HUOBI that TABARAK had verified that the buyer and a partner of the buyer had already had more than enough money in 3 banks in the UAE. That they, sorry, by more than enough money, I mean close to 50 million dirhams, which was more than enough to pay for the 500 bitcoins that were the subject of this particular email.
Yeah, I cannot state anything anymore what I did before.
Thank you. And in fact, this email is consistent with your other assurances to HUOBI that the buyer had funds to pay for the Bitcoin and that this would be paid quickly into TABARAK's client account. And in particular, you informed Mr. Turner, you informed Mr. Al-Ali that the buyer represented a group of, so that's Mr. Morozov, represented a group of Russian investors who had about 20 million US to invest, correct?
Cannot confirm, I don't know what this is.
Right. And when you met Mr. Al-Ali on the 15th of January, you told him that the buyer was good for the money, didn't you?
On the 15th of January.
Yeah.
Can you lead me to some message or so?
No, it came out in cross-examination.
Then it is not correct. Cannot confirm.
And during your discussions with Mr. Saxena, when you were waiting for the buyer on the 30th of January, you told Mr. Saxena that you'd seen the buyer's funds.
I have seen from the buyer the same like HUOBI saw a bank statement. That's correct.
And indeed, in your memory minutes at 8:523,
Just a second, please. Yes.
the second, are you there, Mr. Turner?
Sorry, I have it 8523.
Lovely. The second bullet point says Mr. Morozov proofed the funds via online banking before the deal started. So that's consistent with you having checked that there were sufficient funds in place.
Just to inform you, before the deal started, Mr. Morozov showed on the laptop of Mr. Alexei to HUOBI the UniCredit account. This what it's meant here.
Your Lordship, my phone is about to,
Yes.
5 minutes or 3 minutes even just to charge it and get the charger sorted out.
Yes. Yes.
If you could give me 3 minutes, I'd be most grateful.
Oh, well, I'll give you 5 minutes. So we'll take a break for 5 minutes.
Thank you.
If you need it, if you can do it in 3, you can let us know and we'll get on. Okay.
I'll be back as soon as I possibly can.
Yes,
Thank you.
Mr. Turner.
I can also take shortly this break
Yes,
to go
you
for the
can.
restroom. I will be back.
The only thing I have to tell you is you mustn't talk about the case to anybody during these breaks.
Thank you.
Okay?
Your Lordship, I apologise for interjecting, but I think we're around about the time when the transcribers would ordinarily take a 10-minute break. So I don't know if we can perhaps factor that in now as well, potentially.
Well, that's not a bad idea. Could I just hear from the transcribers, please?
Good morning, sir.
Good morning. A 10-minute break now, and then considerably later on, there's a 30-minute break that we take. Is that all right? Does that suit you? We take 10 now, and then later on, considerably later on, we take 30 minutes.
That's fine. Thank you.
Good. Okay, we'll take the 10 minutes. Thank you very much, Ms. Ahmed. Very good suggestion.
Thank you very much. Can I leave? Can I leave? Mute.
Yes, you can leave, Mr. Turner. Just make sure that you keep in touch in case we can get underway in 3 minutes instead of 5. That was a mistake. We're breaking for 10. There's no question.
Yeah, thank you very much, Your Honor.
You've got a 10-minute break.
Thank you very much, Your Honor. Thank you.
I think we must be close to having had our 10 minutes.
Yes.
And if Mr. Ahmed and Mr. Matu can confirm that they're ready to proceed, we shall get underway. Thank you, Ms. Churt.
Yes, to proceed. Thank you.
Yes.
Thank you.
Mr. Turner, I'd like to turn now to events on the 3rd of February.
Yeah.
So Mr. Alali, Mr. Saxena and Mr. Nahak from HUOBI, they attended TABARAK's offices about 10 o'clock. And it's true, isn't it, that at no stage were any of those HUOBI representatives presented as technical experts in Bitcoin transactions that involved cold wallets.
What you mean presented? From whom presented?
Nobody said, here's a technical, Mr. Alali, for example, is a for example, it could have referred to any of them, is a technical expert in Bitcoin OTC transactions involving Bitcoin, involving cold wallets.
No, they were introduced that Mr. Al-Ali is the owner, Mr. Shantanu Saxena is the CEO, and that Mr. Sushant is the trader and the responsible IT person for this trade. This was the introduction.
Well, he was presented as the OTC trader, Mr. Nahak, wasn't he?
As the OTC trader and responsible for this trade to be done here at the office of TABARAK, yes.
And you were aware that the standard model that HUOBI used was that in the event of a sale of Bitcoin, the buyer would pay the money first to HUOBI, and then only then would they get the Bitcoin. You were aware that that was the standard model, weren't you? Because otherwise they wouldn't need to come to you, would they?
I cannot say if they would not come or something. This was the standard agreement what we had, yeah, until this
No, I think
day
you might
when they came in.
I think you might misunderstand me, Mr. Turner. The HUOBI's standard model for doing OTC trades for the sale of Bitcoin was that the buyer would pay the money first to HUOBI, directly to HUOBI into HUOBI's bank account, and then only then, once the money was in HUOBI's bank account, would the Bitcoin be transferred to the buyer, correct?
I cannot say that this is the standard procedure of HUOBI, but as you followed with me before, what was the final procedure? It says in principle this what you are asking now, but if it's the standard procedure of HUOBI, I cannot tell you.
Well, I put it to you that you were fully aware that that was the standard procedure of HUOBI, and that was why, in this case, they needed an intermediary and why they came to TABARAK.
I cannot confirm this, what you're saying. We had a procedure, agreed a final procedure between the parties.
Okay. Now, so then there was a meeting at the beginning of the events between and at that meeting was Dr. Ahmadi, you, or included Dr. Ahmadi, you, Mr. Saxena, and Mr. Al-Ali, yes? This was before the transaction started.
Before the transaction started, yes, Dr. Ahmadi joined us in the meeting room.
Thank you. And Mr. Al-Ali or Mr. Saxena said something along the lines of, we're pleased that we're to be clients of TABARAK's.
This I cannot confirm, but they had a welcoming between these parties, but please, I cannot recall exactly what they were talking to each other, because it was language in their Arabic language when they were talking.
And Dr. Ahmadi, he responded something along the lines of, well, you're not a client because you haven't paid the account opening fee.
As I said, cannot confirm as they were talking in their Arabic language. But it was a welcoming situation. So everybody was eager and desperate to do a deal. This was my understanding.
And I put it to you, you'll say perhaps that it was, you don't know because it was in Arabic, but we would put it to you that that Mr. Al-Ali's and Mr. Saxena's response, and this was a response that you understood, was that no, it had been agreed that the account opening fee would be deducted from the proceeds of the transaction.
Yes, when you say now Mr. Saxena, then we were on English. It was clearly stated that the account opening fee should be deducted, even when still at this point, Mr. Saxena said that from US account, the account opening fee is transferred to TABARAK, which was not true. But then finally the agreement was done, and Dr. Ahmadi agreed to that finally it should be the fees and all this should be paid from out of the transaction. That's correct.
Thank you. And that was, and his agreement was clear in that early meeting. It would have been clear to HUOBI in that meeting on the 3rd of February, the meeting earlier in the morning, yes?
So please, can you repeat? I did not understand now clearly what you mean now. Sorry.
Okay, sorry, I'm not expressing myself well at all. So this was in English at this stage, what I'm going to put to you, and it was agreed, and it was in the English language, in front of Mr. Al-Ali and Mr. Saxena. It was agreed by Dr. Ahmadi that the account opening fee would be paid from the proceeds of the transaction, correct?
But it was clearly stated and spoken that the fees and all this should be taken out of the deal. That's correct.
Okay. And that they would be taken out of the transaction proceeds.
Well, I think that's what he said. He's accepting.
Okay. And Dr. Ahmadi, he left the room, but before he left, he wished everyone the best of luck. Yes?
Correct, yes. Yes.
Now, so he left, Dr. Ahmadi left, and then sometime soon after, the buyer showed up with this Alexei person, yes?
That's correct, yes.
Now, in relation to the commission, there was some negotiation over the commission that the buyer would be charged for the transaction and what TABARAK would receive from that. And in particular, just going back a little bit, on the 29th of January, you and Mr. Al-Ali had a phone call in which it was agreed that TABARAK would take 0.2% of the transaction proceeds. Do you recall that?
0.2 or 0.25, something in this, yes.
I'll get on to the 0.25, because then what happened was that was based on but then at that stage, it had been agreed that the entire commission that the buyer would be paying to HUOBI was 3%. Yeah?
I think so, yes.
Yeah. Now, but on the 3rd of February, you approached HUOBI and you asked if TABARAK could have a commission of 0.25%, yes?
This is what I recalled, as I said before. I guess it was 0.25%.
Yeah, absolutely. And HUOBI said fine. I think it was Mr. Saxena who said fine, as long as the buyer paid not 3%, but 3.05% in commission. Yes?
I guess so, yes.
And the buyer agreed to that.
Yes, I guess the figures and so this was all clear, because there was even a statement where it was clearly fixed what is the fees, what is the OTC for HUOBI, and what is finally for TABARAK.
Okay. Now, right, just digging in a little bit more detail as to what happened next. So the buyer brought what appeared to be 2 brand new Trezor wallets. They were still in their packaging, yes?
Yes, the buyer, which was very surprisingly brought in a package Trezor wallets devices, yes.
And you asked HUOBI if they were comfortable using the buyer's own wallet, because the buyer had said that he wanted to use those new wallets, or those wallets, yes?
May I give you a few more words? I had our Trezor device with me, and this was agreed to be used. And I said it was surprisingly that the buyer brought, and I asked HUOBI if they really want to do the deal with the devices of the buyer. And they accepted and said, yes, let's go ahead. Only Mr. Saxeno, he was the only one who said, stop. I really have a problem. I think this is not good.
But you replied when he actually asked you, in fact, he asked you whether you had any concerns arising from using the wallets that the buyer had brought. And you replied you didn't have any concerns because once the Bitcoin were transferred, they'd be in transferred into the wallet. They'd be held in the wallet would be held in your safe, to which only TABARAK had access. And sorry, by your safe, I mean TABARAK's safe.
So it's a very long sentence what you made. Something to it.
You assured Mr. Saxena that you didn't have any concerns about using the wallet that the buyer had brought, because once the Bitcoins had been transferred to the address associated with the wallet, they would be safe.
That's not correct. The correct answer, or the correct thing, is that I told them when we have the deal and when we have then, because they asked me, the Bitcoins on the Trezor wallet, my understanding is when we took it and have it for these 2 or 3 hours, what they were asking for, with us, nobody can touch it. And nobody can do anything that something is then not to be used from this device.
Yes, so you were assuring Mr. Saxena that any Bitcoin that were transferred to the address would be safe.
It was not an assuring, it was a discussion which they had, because as I said, Mr. Saxena was the only one who was nearly to decline the deal. But finally he was overruled by Mr. Sultan Al-Ali, because they were, as I said, desperate to do the deal. It was not an assurance.
No, the buyer wanted to set up the wallet, and Mr. Al-Ali said, no, it should be you who sets up the wallet, correct?
That's correct, yes.
So next, you open the cellophane. These are your words.
No, stop. I have to. No, I did not open the cellophane. I showed to every party, because this was then, they asked me if I can just assist them with this. As I said, Mr. Al-Ali said no to Mr. Morozov to set up this. So
okay,
I was.
Can I take
No, let
a
him
memory
finish.
minute?
No, I got.
Finish.
May I just? Sorry, I mean, I just want to finish how it was.
Yes, well, that's what I'm letting you do. Go on.
Yeah, thank you. Mr. Morozov gave me a device which was wrapped in cellophane, which I showed to the parties. All accepted. Then, for my understanding, okay, it was untouched, but it was my understanding. Then I unwrapped the package. On the package, it is surrounded by a so-called seal. I showed the seal to everybody. Everybody acknowledged and said, yeah, fine. Then I removed the seal and I opened, and then I showed the device to everybody. And this was this Trezor device.
Okay, and can I take you to 8521, please? This is part of the memory minutes dated the 12th of February.
Yes.
And at the top, you indeed say that the 2 devices were wrapped in cellophane clear plastic and untouched. I opened the cellophane and took out the package, opened the package and took out the device. I controlled the original seal at the device and showed to everyone in the room. And then you go on to say, I removed the seal from the device. So when you say you controlled the original seal at the device, that's because you were in a position to do so. You were in a position to control because you were in charge of coming up with the process for this transaction, weren't you?
No, but as I already set up by my private trésor the same way, I knew what it is, and I controlled, like all the other persons in the room, controlled the seal.
So you've removed the seal and you start the setup procedure. And what that involves in the first instance is plugging the device into your own laptop, yeah?
Stop. There was before then discussions about the setup procedure between the parties. Because as a trésor device, when to set up newly, you need to have so-called seed words. And these two parties, HUOBI and Morozov, agreed that they will split the seeds 6 by 6. But HUOBI said then finally, no, we will leave the seeds with Mr. Turner with TABARAK, which was then finally agreed, which was maybe a mistake, but okay. And so then we started to set up the procedure.
Well, you initiated the wallet to generate the 12-word recovery seed phrase, which I'm going to call shorthand mnemonic.
Yeah, but not recovery seed. Yeah, in principle, it's a recovery seed because who has the 12 words is the so-called mastermind.
Yeah.
So,
go on, Mr.
now, you'd agree that during the setup process, no one from HUOBI actually touched the Trezor wallet?
No, it was only the package when it was with the seal then, but the trésor device themselves, no, they did not touch.
Thank you. Could I take you to 2764?
The drawing?
Yeah, so this is a drawing supplied by Mr. Saxena. It shows the layout of the meeting room and where everyone was sitting, yeah?
Yes.
So we have Alexei and Evgeny in one corner.
Yeah.
We have you and Ms. Avialova at the other corner,
yes.
we could say. And then on the opposite side, we have Mr. Nahak, Ms. Saxena, and Mr. Al-Ali. Yeah.
Correct. Yes.
It's in fact the case, isn't it, that no one at HUOBI ever saw how the mnemonic, the 12 words, or any of those words actually appeared on the Trezor wallet screen, did they? They never saw that. Because they couldn't.
Honestly, cannot recall, because there was some movement in the room also, how it is. But on the other hand, I mean, HUOBI knows also about setting up a device and all of this. So, but I cannot confirm now, yes or no. When they are sitting there and when we did, we had 6 words, and then finally the buyer has 6 words. Yes.
Well, you say that HUOBI knew about the setup of a Trezor T model, but you certainly never asked them, did you?
No, because I'm sorry to say this, but when HUOBI is the 3rd biggest exchange in the world on cryptocurrencies, and with wallets and with all of this, I guess this question would be like, I don't know how to say this. So they are definitely aware about what, and also they had the trader. And if a trader is not having a cold storage of such a big international exchange, I'm sorry. I guess even this question was not necessary to ask.
Well, I think it's been covered elsewhere during the trial that your assertions there are unfounded. But anyway, we'll move on. Now, your account is that you saw at least the first 6 words of the mnemonic, yes?
Yes, it was done between Anastasia, my assistant, and my side. I made the forward on the words, and Anastasia made on a sheet of paper, wrote down the words.
And Mr. Popper, the expert you instructed, he confirmed in cross-examination that the Trezor is a touchscreen device, and when going through the recovery seed phase, you see 3 or 4 words on the Trezor screen at a time, don't you?
Honestly, I cannot recall, but the device leads you through the process, word by word, which has to be stated then, and which is, let's say, ordered by Trezor to be on a sheet of paper, which is then be stored so that nobody has these words. But the device leads you part by part through the setup process.
And it would have been obvious to you when you saw what appeared on the device that by handing over the device to the buyer, it would be very easy for the buyer to scroll back and see those first 6 words. That would have been obvious to you by looking at the device in front of you.
No, that's not correct what you are stating.
And therefore, it would be very easy, and you knew or ought to have known that it would be very easy for the buyer and Alexei to memorize or note down all of those 12 words.
No,
It?
that's not correct what you are stating.
And yet, you just allowed it to happen, didn't you? You handed over the device and your laptop, to which the device was attached, to Mr. Morozov and Alexei.
I handed it over. It was especially, I guess it was Anastasia then who handed over the device for the second 6 seed words to Mr. Alexei and Mr. Morozov. That's correct.
And in doing so, you therefore allowed them to scroll up and down and to record all the 12 words.
I'm sorry, I'm not allowed them. I even don't know if they did or not did or what they did. And the next thing, if you look at the drawing, Mr. Sushant, which is the trader on OTC, is sitting beside Mr. Alexei. So he should have seen when something is on scrolling, and nobody made any word or something during this process. And I did not allow. When you tell me the word I allowed, I don't know what you mean. How could I allow somebody to recall all of the 12 words? What you want to say to this?
Just to intervene, you've got about 15 minutes so that you're aware of that, Ms. Stewart.
And it was very easy for them to do so, and you would have known it was very easy for them to do so because they could hide what they were doing because
Not correct.
because they were partially hidden behind your laptop, weren't they?
I cannot state anything to this, what you're saying.
Now, there are 2 steps in the setup process that you don't mention at all in any of your evidence. First of all, the verification of the mnemonic. Now, the experts agree that the verification step is a mandatory step. Yes? And so did you carry out that verification step? Did Miss Zavialova? Did you carry it out between you?
It's very difficult to recall this, how it was done. Really, I'm in this case, I cannot make a statement how it was done, if it was so-called recovered or reconfirmed and so on. I don't know. Sorry.
And a further step.
But the Tresor was set up. This was definitely clear.
Now, a further step that you don't mention in your evidence relates to the passcode. Now, the experts agree that the setting of a passcode on the Trezor is optional. Yeah. And
sorry, a what?
A passcode. After the verification of the mnemonic comes.
You mean a PIN? You mean a PIN?
Okay, PIN code, yeah.
Okay, yeah.
Did you set a PIN code?
Yes.
You did. And it was because you set the PIN code and because TABARAK had possession of the physical device. We know that because you had possession in the safe, you stored it in the safe.
Yes, not me, but it was stored in the safe, yes.
Well, you took it to Dr. Omadi's room.
Yes, but I did not store it in the safe because I had no access to anything of this.
You took it to Dr. Omadi's room.
Correct.
And you asked him to lock it in the safe, and he did.
Correct.
That.
Yes, correct.
And the reason you did that was, and the reason you set the PIN code is because it was TABARAK who was supposed to be safekeeping the Bitcoin before payment was made.
It was agreed between the parties. We should keep for these 2 or 3 hours until the money from Morozov or Navarcon should hit the account of TABARAK, the device. Yes.
And in your understanding at that stage, the only person who would have had access to the Bitcoin in the wallet was TABARAK, correct?
At this stage, my understanding was that nobody can do anything without the device and without the PIN code. Correct, yes.
And it would have been the case that had payment not been made, which it wasn't, as we know, by the buyer, that the Bitcoin would simply have been transferred back to HUOBI.
This should happen if no payment will come in, yes.
We also know that as part of your role on that day, you sent a message to the OTC WhatsApp group providing the new Bitcoin wallet address, yes?
I don't recall, okay. But when you have it on WhatsApp group, then it was, yes.
Yeah. And this is in a WhatsApp group, you'd agree in response to a WhatsApp message from Mr. Saxena giving prices that the Bitcoin were booked at, you replied, okay, confirmed by Mr. Morozov.
Yeah, now, okay, now I know where you are. This WhatsApp group was made internal at the meeting so that everybody is on the same level of information. The wallet address was produced by the device and was sent openly on the WhatsApp group. And this, what you are asking about the confirmation of price, was because the both parties agreed to use XE platform chart for the pricing and for the
Yes,
fixing
absolutely.
for the fixing of the
I
price.
don't think
Yes.
that's in dispute. Thank you. Now, so you asked for the that the coins be transferred to the wallet, and Mr. Saxena said he objected to that because the funds, he understood that the funds weren't yet in TABARAK's account, correct?
No, this is not correct, because the discussions about objections was already before,
Well, that
but
was
not
another set of
but not
objections.
regarding the funds, because the funds were already clear that they will be transferred during the next 2 or 3 hours, which was stated in the meeting before the transaction started.
And in response,
And that's why they showed on the laptop the account.
and in response, to Mr. Saxena's objection to the transfer of Bitcoin before the funds were in the account, you said, well, look, it's going to speed up the process if you transfer the Bitcoin now, didn't you?
Can you show me, please, where this is stated?
This is the evidence of...
From whom?
I can't remember exactly, but it was...
It's not from my side. I'm sorry.
Okay. No, it's not from your side, that's for sure.
Yes.
And you insisted it was safe for HUOBI to transfer into the wallet before payment, and that HUOBI shouldn't...
Absolutely incorrect, because as I told you, the structure was already set up at the beginning, and they agreed that the funds will come 2 or 3 hours later, and we should go in the meantime for lunch.
And you said it was safe because the wallet was going to be locked in your safe, and so you had complete control over the Bitcoin. Words to that
Councillor,
effect.
I explained already this before. No other answer like you have before.
Now, after, so there's an exchange of WhatsApps, not least recording the agreed commission, and the Bitcoin were transferred to the address associated with the Trezor device. And then it was decided that you, Ms. Zavialova, all the HUOBI people apart from Mr. Al-Ali and the buyer would go to lunch, yeah?
Sorry, can you repeat?
So it was decided that all of you, with the exception of Mr. Al-Ali and I think Alexei, were going to go to lunch.
So also I need to explain a little bit more here. When the Bitcoins were transferred, both parties asked me to go with them to Dr. Ahmadi to hand him over the device so that he is storing this in the safe of TABARAK. This was done. After this, we went all together to lunch, and at the exit of the meeting room, this Mr. Alexis Sochin stated that he has another meeting and he will come back in 2 hours. Correct.
Yes, yeah, okay.
But all other parties, also except Mr. Sultan Ali bin Kasham, because he also said he has a meeting. But the other parties went to lunch to Burger and Lobster. Correct.
Yes. And then at one stage, when you'd taken the decision to go and, because obviously you had to lock the, actually forget that. At one stage, you, the buyer, and Mr. Al-Ali were all in Dr. Ahmadi's office, weren't you?
As I said, yes. because they wanted to see that I hand over the device to Dr. Ahmadi, correct?
Now, that office is quite small.
No.
And Dr. Ahmadi said something to the effect that he was very happy that the deal had finally been done. Yes, something along those lines.
The office of TABARAK is not too big, that's correct, but we had to go from the meeting room on one end to the other end. We had there some small talk, as I recall, and Dr. Ahmadi congratulated for the, for finalizing at this stage. And we told them that we are going for lunch now and we'll come back. And in the meantime, Mr. Khan, as he's the CFO, should have a look on the TABARAK account regarding the inbound of the money sent by Navacon, correct?
And it's true that when all of those people were in the room, not Mr. Qadir Khan, but Dr. Ahmadi, he put his arm around Evgeny's shoulder and he said something along the lines of, "Oh, he's one of our best clients."
I'm sorry, who said this?
Dr. Ahmadi.
He put around the arm on the. Sorry, I cannot
say,
confirm.
"Oh, he's a really good client of ours."
I cannot
Something
confirm.
like that.
Sorry. No.
And Dr. Ahmadi also said something along the lines of, TABARAK had been trying to execute this deal for a long time, and that he was very happy that a seller had finally been found for Bitcoin.
I'm sorry, I cannot recall on this exact wording what was stated. It was a small talk, as I told.
Now, Your Lordship, I've probably got about 10 minutes left.
No, you haven't. I'm afraid I've had you on my stopwatch throughout, and we paused it for the 10 minutes. You've got a couple of minutes to go, and you will have had 100 minutes, 1 hour, 40 minutes.
I don't know whether Your Lordship saw my email that I need much less time with Miss Saviolova. So maybe if I could be indulged for 10 minutes, I'd be most grateful.
Well, okay, just wait a moment. Let me just see now, Mrs. Yes. So I was allowing 45 minutes for Miss Saviolova. What can you tell me about the time you will be with Miss Saviolova?
I won't be longer than 20 minutes.
Okay, you can have another 10 minutes.
Can I take you to 8528, please?
Yes, I have it in front of mine.
So this is an email that you sent to the buyer, copying HUOBI and copying Anastasia and Dr. Ahmadi, yes?
And Mr. Saxena, yes. And Mr. Sultan, yeah.
Yes, yeah.
Everybody, yeah.
Now what you say in second paragraph, third line from the bottom of that paragraph, you and your Russian companions just misused our bank to convince HUOBI to enter the deal with Navacon.
Yeah.
So you are acknowledging here that you did convince HUOBI, that TABARAK did convince HUOBI to enter the deal with Navacon, correct?
It's not correct, it's your suggestion, but at this time it was my impression, because I'm still knowing that we are all innocent and the two criminals are Mr. Morozov and Mr. Alexei Sochin, and this was my impression, and this is what I expressed here.
And then if we go to the last paragraph, sorry, the second to last paragraph, you say you will have to do a written commitment with HUOBI and us, TABARAK, to settle your responsibility against HUOBI and also against us, TABARAK, because you said that because you knew as TABARAK that you were accountable for the loss caused by the theft of the Bitcoin, didn't you?
No, that's not correct.
Now, we know that on the 19th of February, you wrote a resignation letter.
Yes.
And then you actually continued to be employed by TABARAK until June, yes?
Yes.
And is it the case that you, when you returned from the police station and you continued being employed by TABARAK, you continued to represent TABARAK to clients and potential clients of TABARAK?
I did not even do anything anymore. I wanted to resign. Dr. Ahmadi wanted me to keep me at TABARAK to assist him in this case. I had not anymore one contact with one client, and I did not anymore because I was, first of all, I was shocked when I called the police that I was taken from police. Secondly, I was shocked that Dr. Ahmadi did not even do anything to help me. Third, I just wanted to go away. That's all.
Now, final topic, your laptop and mobile, they were confiscated by the police, weren't they, on the 3rd of February?
Yes, but not only mine, all of the involved parties.
Yeah.
Beside HUOBI, from them, nothing, which is very interesting, but anyway.
And you knew that proceedings had been issued against TABARAK by HUOBI. You knew that in March 2020, yes? Round about that time.
Yeah, and because there were then many discussions internally with TABARAK and about investigation, about technical issues, how we can do, and also how we can trace maybe, and so on and so on. Yeah, I even don't recall exactly, but okay.
And you became a party to these proceedings in September 2020, didn't you?
Yeah, I was announced as a defendant.
Yeah, and you finally engaged in these proceedings on the 1st of February of this year when you showed up at a hearing.
Yeah.
Now, I won't take you to the many documents, but it's fair to say that there was a period of when, first of all, standard disclosure was exchanged by the parties. So that was in July of this year. Yeah. So that's disclosure.
What do you want me to? What do you want me to say, or what do you want to me to answer?
Miss Stewart is setting the scene. She's reminding you that on that date, I think you said July of this year, there had been standard disclosure. That means that documents were disclosed by the parties on a standard basis.
I apologize that I'm not familiar with all of these law things, what's going on, but
I understand.
I was already involved, and my lawyers also.
Yes. She's just setting the scene, and I don't think there's any dispute about it.
Okay.
In July, there was standard disclosure. Documents were disclosed between the parties on a standard basis. Yes, go on, Ms. Stewart.
And then there proceeded a period whereby each party was making requests of other parties to produce documents, and also parties were putting in objections, were making objections to those requests, yes?
Yeah.
And ultimately, there was an order for production of documents made on the 12th of September, with documents due to be exchanged on the 23rd of September, yes?
Well, we
This
know
year.
that's the case. Yes,
Yeah,
this year in
okay.
September,
Yeah.
there was an order that certain documents must be produced and by a particular time.
Yeah.
Yes, go on, Ms. Stewart.
And you agree that Charles Russell, having considered what you had considered your disclosure, they sent a request for further information from you. And that was about the 7th of October. Do you recall that?
No.
And
I cannot see
okay,
here.
do you
What is the
agree?
question, or what you want to know?
And
Well,
it
first
was
of all,
only
Ms. Stewart wants you to accept that there came a stage in September when the lawyers for HUOBI served a request for information, that is asking questions of you on particular topics, and your lawyers would have received that. And as I remember, a reply to that request was served. You would have been involved with your lawyers coming up with what the reply was. And I think that's common ground. There's no dispute about that.
and it was only on the 19th of October when you responded to the claimant's request for further information that you revealed that your laptop and mobile had in fact been returned to you by the Dubai police. And in fact that it had been returned to you as far back as May 2021. Okay, well, that's what those documents.
First of all, I have to say I had several requests to my lawyers regarding the devices, and the devices were not given to me. They were handed over, as I recall, to the lawyers, but I don't know exactly when it was. And so, because it was an extreme long time, they did not find it. The police said they don't have it. The public prosecutor said they don't know, and so on and so on. Yeah.
And you may not recall the details of this, but then the claimant's solicitors, having been told about the devices having been returned to you, sent 2 further requests for information.
As I said, I'm still in contact with TABARAK. We had several issues daily. Mr. Malik gave me a questionnaire from the other party of about 100 or something questions and so on, which I was working on because I had no chance to access something. But with TABARAK, I had access. Yes.
Now, and finally, you responded to questions of the claimant's solicitors in a response dated the 4th of November. And if I could take you to 2110. Mr. Thurner, I think you might have muted yourself.
Sorry?
Oh, no, it's okay. He's not muted anymore.
I have it in front of mine on the screen.
Good, thank you.
Good.
Now take him to the bit you want.
Yeah. So at paragraph 9, you explain that after receiving the devices from CID/Dubai Police, I was unable to use the laptop and the phone. Based on my recollection, on or around the 27th of May, I handed the device to Mr. Maksud, and then in a nutshell, it was found that they didn't work. So then we go on to the next paragraph, where you say that after that initial review by Mr. Maksud,
Yes.
he handed the devices to Mr. Martin Weiss, our Director of Risk and Compliance and Head of Security, including IT security. Mr. Weiss was formerly the Head of Government of Austria's Department for Investigation, Counter-Radicalization, Counter-Espionage and Proliferation, Counter-Terrorism, Counter-Terrorism Financing and Money Laundering, IP Unit, and Operative Analyses, and Second Deputy Director of the Austrian BVT. Yeah?
Correct, correct.
And then a bit further down, you say that Mr. Weiss didn't have any success. So what the highly qualified Mr. Weiss then did was that he took the laptop and the iPhone to an electronic market in Al-Saka and asked a technician in a mobile shop.
Councillor, long story short, I handed it over. I did not take it back anymore or something like this. They just told me something the CID had been done or the police. It was not anymore usable, nothing. And then I even don't know what happened. That's all.
But it's your case that this highly qualified expert, Mr. Weiss, went down to a local electronic market, walked into a mobile shop and said, could you take a look at this?
I don't know if it is a mobile shop. I don't know about this, what he did. You have to ask him.
Where are we going on this, Miss Stewart?
Well, I would suggest to you, Mr. Turner, that this is the most fantastical story. And it's quite extraordinary that even though you knew you were in the middle of litigation, that you discarded the devices.
You said what? It's the what you said?
The point, we do know that you discarded the devices because you've told us that.
Your councillor, first of all, it was in a so-called proceeding of the public prosecutor. There, it was a so-called statement that cause of reconciliation between HUOBI and Mr. Morozov, the case was dismissed. That's the reason. And when I get devices, and when I get back devices, yeah. So what shall I do? For what reason I get the devices back? And I tried to open them, but they were not working. It's absolutely, it was nothing, not even a single thing happened with this.
And you say that you were informed by your lawyers to preserve documents, yes?
The preserving of documents was done by the CID and police, your councillor. So what, you have everything.
Well, Mr. I don't think.
Yeah. Okay.
I don't think we need to pursue this any further. And I think I think probably, unless you've got some ace up your sleeve, this is you really ought to bring things to a close now in your cross-examination.
Yes. There's just one more point, very small point. I could take you to 6106.
Yes.
And paragraph 10
Yes.
You say it's my understanding that the claimant, so that's HUOBI, was a client of the first defendant, namely of TABARAK. So
Yeah.
you agree, so as far as you're aware, it was the case that HUOBI OTC was TABARAK's client.
Under this
On
deal,
the
it should
third
be
of-
this way then, yes. But as the deal was not executed as it was on the procedure, it was not. The deal, it stated the deal, your counsellor.
Thank you. That concludes my.
Thank you very much. Now, Mr. Turner.
Unbelievable.
Now, Mr. Turner, don't make remarks like that. They don't help. They just don't help. You're going to be cross-examined now by Ms. Ahmed. Now, if at any stage, I appreciate that it's a stressful business being cross-examination and examined in the case. If at any stage you want a short break just to sort of clear your head, if you like, or to go to the restroom or whatever, just ask me, and I should be sympathetic. You understand? If you want a break at any point, just let me know.
Yeah, I'm sorry that sometimes I'm a little bit emotional, but as I said, the parties agreed to something, and I am the only victim which was going to custody, which was overwhelmed with answers and questions which are not true, and all this, and then I have to stay calm. Okay, yeah. And I was the only one who did never ever change something in statements and so, and I read that they read everything, changing statements and so on. And I'm sorry when I'm a little bit emotional on this.
Well, I quite understand, and I know I have your cooperation to do your best.
Yes, absolutely, and I apologize to every party, but as I said, when I recall all of this, I really could cry on this, because I was very stupid by letting me misused by all of these parties.
Well, and I just repeat, at any point where you'd like a break, just ask me, okay?
Yes.
Right, Miss Ahmed.
Indulgence in two matters. Well, the first one is, Your Lordship, we can't see you on the screen, and I don't know if that's deliberate or inadvertent.
You can't see me?
No, I can't.
I can see.
I also cannot see you, Your Honor.
Oh dear.
I cannot see you, my lord.
Oh, that's a shame.
Yeah.
But the camera's on, the green light's on, and I haven't switched off the scene.
No.
Well, look.
The other point
But I can hear you clearly.
Okay, well, I think we carry on an audio basis. Might be better for everybody.
Your Lordship, may we rise for a couple of minutes for a short comfort break, please, before I start? That was the first indulgence I'm seeking. And the second one is, very much like my learned friend, Miss Stewart, in relation to the very helpful timetable that you proposed, I think I'll take as long as the proposed 45 minutes with Ms. Zavialova. I'm likely to take 10 to 15 minutes, if that. And so I was wondering whether or not I could tag on that time to Mr. Turner.
Well, I'll start by tagging on a further 10, and we'll see how we go. Right, we'll take a break, 4 minutes for a comfort break before we. Right.
Thank you. Thank you.
So please begin your cross-examination, Ms. Ahmed.
I'm grateful, Your Lordship. Thank you. Good afternoon, Mr. Turner. My name is Bushra Ahmed. I'm representing TABARAK in these proceedings.
Good afternoon.
Good afternoon. Can I ask you to turn up your first witness statement that you prepared in these proceedings? It's at 6-106.
Yes.
You have that there? And paragraph A.
I have it.
You say
Paragraph.
Yes.
I'm not starting with I'm not a cryptocurrency expert.
Yes. Yes, that's right. You're not a cryptocurrency expert involved in Bitcoin transactions as a professional. Further, at no point have I ever been instructed in personal capacity or otherwise to structure a Bitcoin sale and purchase deal agreement and put together a deal structure term sheet for such transactions. You see that there?
Yes.
And therefore it's correct, isn't it, that in no way are you an expert at buying and selling cryptocurrency or the safe handling of such a transaction, are you?
That's correct. I'm not a professional expert.
Yes, and I'm going to suggest to you also that you've never held yourself out either to the world or to HUOBI in this context as an expert in the buying and selling of cryptocurrency and the safety and security of handling cold storage wallets. That's right, isn't it?
That's also correct, yes.
And in response to a question that was asked by my learned friend, Ms. Stewart, you said your profession is in the financial industry to raise capital. And in fact, that's where your professional expertise lies, doesn't it?
Correct. As a director of investments, yes. And to invest the money from the clients then correctly.
Now, in early part of 2018, it's right, isn't it? And you've accepted that you were in touch with Dr. Ahmadi from TABARAK in the context of purchasing 20% shares in TABARAK as the COO. That's right, isn't it?
That's correct, yes.
And at the time, it's right also, isn't it, that you told Dr. Ahmadi that you represented a group of European investors who were interested in purchasing TABARAK's shares?
Yes, that's also correct.
And what you had in mind at that point was to establish a fully integrated trading desk, which would be responsible for the gold trading department. That's right, isn't it?
Yes. Physical gold trading should be a part of TABARAK in future, yes.
Yes, in the future. And it was suggested to you by Ms. Stewart, when she was asking you questions, that that would mean that TABARAK would understand the underlying mechanism of how financial instruments ought to work. And your response was yes. But it's right, isn't it, that in the context of what you wanted to do with TABARAK, one may have a general understanding, but that's not specific to how to safely buy and sell cryptocurrency. That's right, isn't it?
Yeah, just one additional statement to this. We had a lot of discussions about the so-called wording of services. And as it is here, crypto is in the world of Dubai a non-go at retail banks, but digital assets and asset management. And asset management is of a category 3 like TABARAK, a main issue. So we had some discussions how to work and how to handle this. But the main issue was that we should provide for Pecunio the storage, which means the custodian service for the physical gold, the purchase and the handling of the physical gold. This was the intention.
Yes, so handling of the gold, but not handling and custodial services of Bitcoin. That's right.
No, here was another construction in mind, but okay.
And Pecunio is a blockchain company, and you're the COO, that's right, isn't it?
Yeah, but as I said, the position of the COO was there just to overview the investments of my side and of my partner. And yes. So to set up a organization structure, but not a technical Bitcoin or crypto something, because this was not my task. Yeah.
Absolutely, absolutely. And just because you have that company, it doesn't give rise to any sort of expertise, does it, as far as you're concerned, in relation to buying and selling cryptocurrency in a safe manner, does it?
Yeah, as I said, I'm not a professional expert, but I know how to use these things, because I guess I'm in this world, when you do something on purchasing and buying by yourself, you have a knowledge, but I'm not an expert.
Yes, and I think you've also given evidence towards the end of your cross-examination with my learned friend, Ms. Stewart, that you didn't know, did you, that there was a scroll mechanism on the cold storage wallet, the Trezor wallet that was used on the day of the transaction, did you?
This is something absolutely new for me, which I never used, and so because I never had some stolen things and so on. Yeah, so I was a little bit surprised about this. Yes.
Yes, and there is no evidence, and in fact, HUOBI never specifically asked you, did it, whether or not you knew how to operate a Trezor wallet safely or securely, did they?
No, they did not ask. And the same was my understanding from them, that they know what it is. They just wanted to have some neutral ground, as I stated. And I mean, we were stupid enough to agree to this, yes.
And had they asked you that question, you would have said, as you set out in paragraph 8 of your witness statement, I don't know, I can't provide that sort of expertise because I'm...
Sorry. The same paragraph, yes?
Yes, had they asked you whether or not you can operate a wallet safely or securely, what would you have said? I'm assuming you would have said what you said in paragraph 8 of your witness statement.
Yeah, I'm not a cryptocurrency expert involved in Bitcoin transactions as a professional. That's correct, yes.
And the Pecunio deal didn't really go anywhere, did it?
No, it looked very nice, but finally they could not bring the funds. And so it was, it was not possible to go on.
So in early part of 2019, you approached Dr. Ahmadi for a job, didn't you, with TABARAK?
In principle, Dr. Ahmadi offered me finally a job to be with TABARAK, because before I was a consultant already. So I had in principle a little bit of double role when this was with Pecunio, but it was in my intention that because of TABARAK with the gold and all this, it could be nice. And then finally I became director of investments at TABARAK on an employment contract with a visa. Yeah.
So, and Mr. Turner, my instructions are that you were never a consultant with TABARAK, and in fact, you approached Dr. Ahmadi for a job because you said to Dr. Ahmadi, look, I represent a group of investors from Europe. I can bring European clients wherein TABARAK would be able to provide financial services to them. And that's the basis upon which you came to be employed by TABARAK. That's right, isn't it?
Your Councillor, I cannot recall exactly how the situation was, but definitely, and this was also can be shown in the records, I brought a lot of European clients. So I guess as it was part of this, otherwise Dr. Ahmadi would not appoint me as a director of investments.
Yes,
but I cannot recall exactly what the wording is or what it was.
Yes, and that was the basis upon which you were employed. And also, can I ask you to turn to 8-627? This is the CV you gave to Dr. TABARAK, isn't it?
Just please, just a second.
Yes, of course. My apologies.
8-627. 8. I have it. Yeah.
Yes.
It's my curriculum vitae.
Yes, it is, and this is the basis, or rather, you gave this to Mr. Ahmadi, and it was on this basis that you were given a job with TABARAK, isn't it? In 2000.
Sorry, once again the question. I gave this to Dr. Ahmadi.
Yes, when you came to him in 2019, asking him for a role in TABARAK.
As I said, I cannot say if I'm asking it, but we had a lot of communications, and the documents were requested by TABARAK, by the HR. There was a CV, there was some passport copies, and so on. Yes, it was requested by TABARAK to give it to him. Yeah.
And nowhere do you say in this CV, do you, that you have conducted cryptocurrency transactions or anything related to cryptocurrency, do you?
That's correct, yes. I only, as I said, in these discussions, what we had, we were talking about the new world. Everybody was talking at this time about Bitcoin, about digital assets, and so on. But I'm, as I said, I'm not a professional, but as I am director of investments, and so I should also have a look on future possibilities and products. And this was my role. Yeah. And in the discussions, we had some discussions about this.
Yes, I appreciate that. Maybe you would have had discussions about the new world, cryptocurrency, where the world's going, but you were not brought on, were you, to provide cryptocurrency services or to head up a cryptocurrency department, were you?
No, no.
Yes, and your role was simply to bring in the business for TABARAK from European investors, which you did.
Yeah, and also to have a look for new aspects of products and business. Yeah.
Now, can I, and in that respect, let's go to your employment contract. It's at 8-41.
Just a second, please.
8-41.
8. 41 or what? Or 41?
41.
841.
841.
Yes. Yeah, I have it.
Yes, and paragraph 1.1, you see there that you shall serve the employer in the capacity of investment manager. You see that there?
Yeah.
And there is nothing there, is there, about you heading up some cryptocurrency department, is there? You accept that, don't you?
No.
And if we turn to 8-42.
So on the next page.
Yes, the next page, and it's paragraph 2.
Yes.
And it starts the previous page. In your capacity as senior manager, the employee's scope of work includes as follows, and we see that there.
Sorry, just once more. Once again. Which paragraph is 2.1?
I'm looking at 8-42.
Yes.
Yes. And it's right, isn't it? This sets out your scope of duties. Paragraph 2.
Paragraph 2, yeah.
Yes. And these duties are in the context of providing financial services in accordance with TABARAK's license, aren't they?
Sorry, it starts on 841 and it continues on 842. That's why I did not find it. Okay, yes.
Apologies.
In his capacity as a senior manager, yeah.
Yes, in your capacity as a senior manager, and 8-42, the scope of duties, paragraph 2, those were in the context of providing financial services in accordance with TABARAK's license, weren't they?
Correct, correct, yes.
And there's nothing in there within your scope of duties, is there, in relation to assisting, advising in relation to cryptocurrency transactions? Because in fact, that's not what you had any expertise to do, did you?
It's not only regarding my expertise, as I mentioned already before to Ms. Stewart, that cryptocurrency is a word that's still in UAE not very, very good to use for the retail banks. Yeah.
Yeah, and if we go over the page, 8-43.
Yes.
Paragraph 4.2, the employer shall abide by the laws and regulations of the DIFC, the DFSA, as well as the employer's policies and internal regulations. So you understood, didn't you, as part of your role as an employee, you were obliged to comply with rules and laws of the DIFC, DFSA, and internal policies of your employer, weren't you?
Yes.
And if we go to 5.1 on the same page, paragraph 5.1.
Remuneration, yes.
Yes, in consideration for the employee working for the employer and observing and performing his duties, covenants and obligations herein contained, the employee would not be paid a basic salary, however, shall be paid 20% of any account opening fees and 25% net of any profit he generates for the company for completion of transactions. And the reason why it was agreed that you would not be paid a basic salary, because in fact it was you who came to Dr. Ahmadi and asked for the job. And so he said, well, I'm prepared to give you a job, bring in the European investors, and if you do, and if you're successful, you can earn a commission. That's right, isn't it?
Incorrect. We had a discussion. He offered a fixed salary and I declined. I said, I just want to be paid for things that I'm bringing to TABARAK on success fee. But then when I want to be there, I want to be paid really reasonable. And that's why I wanted to receive 20 to 25%, but had nothing to do that I was asking for a job. But we had some discussions, as I told before, regarding the job, and it was an agreement between him and me. So.
And it's right, isn't it, that you agreed that you would be paid 20% of any account opening fee, and so therefore it was important to you, wasn't it, by way of you earning remuneration, that the account opening fees would be paid by any potential client?
It's correct. It's the same like you are charging hours.
Now, it's right, isn't it, that in addition to you providing services to TABARAK under this employment agreement, at the time you were also the CEO of OCS International FZE from July 2019, weren't you?
Yes.
And it's right, isn't it, that that was also a vehicle through which you were generating remuneration?
Your Honor and Councillor, I need to talk some more words about this now.
Well, Mr. Thurner, I'm on limited time. You can please just answer the question. Were you or were you not generating income from OCS International FZE?
Sure. I mean, this is the reason to have a company, yeah?
Yes, and that
That's
was
the, yeah, okay.
and that company was incorporated from July 2019, wasn't it?
Yes, but just for your information, and this shortly, it was in accordance with TABARAK, because TABARAK had to give the NOC letter, which means a non-objective certificate, to open the company, because it should be in use, as I said, for the new business, so that TABARAK is not infected by any Bitcoin transactions and so on. This should run through OCS, which is a free zone company only in use for small business in Umal Coin. So that's just the answer for you.
Okay.
Yes. So that was used to run Bitcoin transactions, was it? The OCS International?
Yeah, because as I said, we had with Dr. Mari, I had a lot of discussions and how to handle, how to act, how to bring these services. And so this was one part. And also this, when you come later on to this vice versa accounting between HUOBI and so on, HUOBI should be the custodian service for Bitcoin, and TABARAK should be the dirham, the conservative part on fiat transactions. And
well,
OCS should be the receiver of Bitcoins and executing with HUOBI. This was the true story.
Well, I'm going to suggest to you that any agreement that you say now was not in fact reached with Dr. Ahmadi. But going back to your company, OCS International, Mr. Thurner, please.
Was not.
Going back to your company, OCS International, it says here that it provided management services, marketing services, financial consultancy and advisory, commodity trading, and digital asset services. That's right, isn't it? That's what it does.
It's a part of this related to management and marketing service and professional services, yeah, guidance and consultancy and advisory, correct.
And in June 2020, about 4 months after the transaction on the 3rd of February, you set up OCS International Finance and the DIFC, didn't you?
Yes.
And you are the CEO of that company, aren't you?
Yes.
And so you are an authorised individual as well?
Yes.
And when you joined TABARAK in or about February 2019, you always knew, didn't you, that you were going to set up your own company in the DIFC?
I was not in an intention to do something like this, yes.
But when you started your employment, or rather when you got into your employment with TABARAK, you intended, didn't you, to open up your own company in the DIFC to provide services?
No, I did not intend. I even did not think about.
When did you first start thinking about it?
After I was let down in custody from everybody.
Well, I'm going to suggest to you on instructions that in fact, when you started your employment, you had every intention of opening up your own company in the DIFC eventually.
It's your suggestion, Councillor.
And it's right, isn't it, that you had your own personal assistant, Ms. Anastasia Zavliova?
Yes.
And in fact, you were paying Ms. Zavliova's remuneration, weren't you?
Yeah, full story. Dr. Ahmadi agreed that we are hiring, but he said, I have to pay by myself because he thinks I can do all of the work by myself alone. But at this time, according to records, he earned out of me approximately 100 to 125,000 US dollars a month. And this was quite a big amount of services to be provided and so on. And that's why I hired under TABARAK employment, Mrs. Zavliova. Correct.
Mr. Turner, can we go back to your employment contract, please?
Yes.
Yes, it's paragraph 9. It's at 845. 8-45. Can you see paragraph 9 there?
Just a second. Yeah.
The employee shall be entitled to
authority to sign.
Yes, the employee shall be entitled to enter into specific legal transactions and or other agreements on behalf of and for the account of the company in terms of a written authority provided to his by the board of directors. So in order to enter into any specific legal transactions and or other agreements on behalf of TABARAK, you require, don't you, written authority under this employment agreement?
What you mean I required authority under this agreement? I mean, I have in my role as an director of investments, I have specified what is my role, what I have to do, and that's it, yeah.
Yes, and you've signed this agreement, it's on the next page, you understand it, you've read it, haven't you?
Yes, yes.
So you understand, don't you, that you've agreed as part of this employment contract that in order to enter into specific legal actions, transactions, other agreements, you would require a written authority provided to you by the board of directors. You've agreed to that, haven't you?
By Dr. Ahmadi, which is a shareholder, and that's why this is stated, I guess, yes. But board decisions to every client, I don't think that this would be a job as usual. It was agreed definitely between Dr. Ahmadi and me. I'm not allowed to sign. I just can bring clients, and he has to give the decisions if we work with or not.
Right, can we go to the 16th of December meeting, please? And thank you for that, Mr. Bernard.
To which?
Yes, so rather than putting you sort of general questions, I'm going to take you to the email, and hopefully I'll ask some questions around that email. It's 8-89. Yes, I can't hear you, Mr. Turner. Mr. Turner, I can't hear you, I'm afraid.
Sorry. Yeah, I have it. 8-89.
That's it. That's it.
And you've been asked a number of questions about this email by my learned friend, Ms. Stewart, but I'm going to ask you some more. If we turn to your first witness statement in these proceedings, or rather your fourth witness statement, it's at 6105. And I'd like you to turn to paragraph 17, which is 6-108. And you say there, as far as I understand, all the terms of the deal, including the structure of the BTC transaction, were exclusively agreed by the claimant and Nava Khan and Mr. Morozov. Further, as far as I'm aware, the first defendant was not involved with respect to structuring or finalising the terms and structure of the BTC transaction. You see that there?
Yeah, I explained it very clearly already to Mrs. Stewart.
Yes, I understand. Can I then take you to your eighth witness statement that you prepared in these proceedings?
To where? To where?
7-51.
Yeah. Yes.
Yes, and before I take you to that particular paragraph, I just want to ask you a couple of questions about your understanding of what happened before you wrote that email. Now, you may or may not be aware, but evidence was given by Mr. Al-Ali that by the time they came to TABARAK's offices, there'd been a call, a meeting in Dubai Mall, several other meetings, and a pre-meeting at the Four Seasons Hotel. You also gave evidence this morning or this afternoon that the buyer and seller had been involved with each other for about a year. Is that correct?
This was my understanding, yes.
So, as far as you were concerned, Mr. Ali came to that meeting and he would have explained to you the basis upon which he wanted the transaction to work, having discussed it with the buyer beforehand. Is that right?
They must have discussed it before, and there were some meetings from them before, and they had several, what I now see and what also then I was informed that they tried several deals between themselves. So they must have been talked to each other. There must be information about financials and so on. It cannot be that what they are stating now, that nobody knew anything. I mean, incredible.
And in response to a number of questions put by Ms. Stewart, my learned friend, you said that the reason why they wanted, or rather it was put to you about the purpose of coming to TABARAK, and you said in response that they wanted a neutral venue. It's also right, isn't it, that not only did they want a neutral venue for the transaction, but they also wanted to have use of TABARAK's dirham account, didn't they?
It was one part that TABARAK should be as an investment bank and as providing account service. That's correct, yes.
And it's right, isn't it, that you would have said that all of those, or all of that could be provided, but subject to an effective account opening agreement. And when I say effective, subject to the terms and conditions in that account opening agreement.
Yeah, and there are two major points. Number one, they did not pay, they lied to us. It was several times that always it is transferred. And number two, they changed something which they agreed before on the very last day, and they want to make us responsible for, which is incredible.
So they turn up at the meeting, and when I say ter, it's Mr. Al-Ali. You're there, they explain to you what
Sorry, you were a little bit, can you repeat? Sometimes you are very quick with your, and sorry, no, not feel offended, but please, can you be a little bit slower, a little bit, please?
Yes, no, I appreciate your observation. I will try and take it slowly, and if I go too quickly, please tell me.
I'm Austrian. I mean, I'm aware of English, but I'm Austrian, please.
Das ist nicht problem. So, Mr. Turner, Mr. Al-Ali turns up at the meeting, having already fleshed out the deal with the buyer, and you say that and you said in response to a question that they wanted to find a way to do the deal. And I'm going to suggest that that deal was always between the buyer and seller. It was always the decision of the buyer and seller how to execute the deal, wasn't it?
It was, and they were so desperate to do this deal. I mean, I now understand why. When I was listening to this trial, I understand why HUOBI was so desperate, and I understand in the meantime why Morozov was so desperate.
And why? Why do you think they were so desperate?
First of all, I understood that HUOBI was in deep troubles with the owners, that there was no OTC business, nothing. And Morozov, they wanted to finalize at least now one deal, because, I mean, this is something we investigated in the meantime. Morozov was also in deep debts with his event agency and with the Chechenian people, which sent this Mr. Alexei Sochin. But this is something of my investigation, because I told you I hired Mr. Martin Weiss, Deputy Director of Austrian PVT, which is the Secret Service of Austria. So we have access to Russia, we have access to several services and so on, and we got a lot of information about these people. So and Mr. Alexei Sochin is even by Interpol on the watch list for crime. And they, I mean, but nothing was shown before when we checked with Mr. Malik about this. No, but zero. You could not find anything in WorldCheck, zero. And this is for me non-understandable.
Yes, so is it right to say then that you sensed that desperation at the time, but now you understand why they were so desperate?
I mean, it's now, but yeah, you always are in better knowledge after something happens.
Yes. And so they come to the meeting, they tell you what they want, and you then write this email at 8-89. So were you asked to send a note of the meeting after the meeting?
Okay, what is the question?
Yes, the question is this, that the meeting happens and you are then asked to send a note of the meeting, and that's why you send this email at 8-89. Is that right?
Yes, I mean, my understanding is always to have all involved parties on the same level. And this was the final agreement between these parties, and I made a statement, and maybe sorry about my English or something like this, that this should be now like I had checked something and whatever. It was always between these parties, and this was then the deal structure. And what was for me so non-understandable is on the next day they are coming and everything is different. I mean, this is unbelievable. Yeah.
Fine, Mr. Werner, but at no point, I mean, it's correct, isn't it, that you didn't voluntarily propose this structure, did you?
No, they put the both parties, and I was like the mediator for both parties to write something down so that they are on the same level, and they wanted to become client of TABARAK, they wanted to do it in our offices, because they said it's so-called neutral common ground.
Right.
Okay.
And what you're not doing in this email, are you, is somehow saying, oh, look at me, I know how to operate a Trezor wallet safely.
Well, Ms. Ahmed, I think that really is a matter for me in construing this document. I've heard the witness's evidence when he was cross-examined by Ms. Stewart, where his evidence was that he's simply recording his understanding of what's been agreed between buyer and seller. But ultimately, it's a question for me to determine what a reasonable bystander, how reasonable bystander would construe the language in this email. So I think we can.
Thank you, Your Lordship.
Yeah.
And after you sent this email, at the top we see, on my copy anyway, FYI and discussion tomorrow morning over the phone, and that's between Mr. Al-Ali Saxena and Mohit Davar. Yes?
Yeah, I see it.
And so after this email was sent, nobody from the claimant approached you, did they, to say, Mr. Werner, what we are expecting from you is for you to provide services in relation to the safe sale and purchase of Bitcoin. Do they?
No, nobody provided any more or contacted me. And in the light of all of this, what I know now, even this HUOBI needs to know on the day before that Morozov is bringing some own devices, because this was one of the major parts in this agreement with money in part, when HUOBI is always stating money in part. On the other hand, yeah, when we should provide service, we need to use our devices and not something else. So they have been known what's going on. And here they stated further for your information and discussion tomorrow morning over the phone. So, yes. And then on the next day, we had this, what they discussed and what they agreed internally. Yeah.
Yes. And Mr. Werner, you're the author of 3 emails in relation to what's been called as the deal structures. 16th of December, the 20th of December email, and the 19th of January email. And in relation to all 3 emails, when you send them, nobody from HUOBI comes back to you and says, hang on a minute, we are expecting you to provide services in relation to the safety of an intended transaction of the sale and purchase of Bitcoin.
Correct, and it shows that they changed 3 times, always something, and they were in negotiations. That's all.
And following those emails, nobody approaches you or comes back to you from HUOBI and says, well, Mr. Werner, if something goes wrong, I'm going to hold you and or TABARAK liable. Nobody says that to you, do they?
Correct, yes. Nobody.
And had they said that to you, you would have surely said, no, I'm not taking responsibility for this transaction.
Sorry, can you repeat this, because you were just slightly away? Once more, please.
And had they said that to you, what you probably would have said is, no, I'm not taking responsibility for this, for the safety and security of this transaction.
Yeah.
You've also given evidence about the claimant that they have a buy and sell exchange. There was a trader there on the day of the transaction. And it's right, isn't it, that you would have expected the claimant to be more, or rather to have more expertise in these sorts of transactions than you?
So here, once again, regarding, when you state regarding seller side, HUOBI is the 3rd biggest exchange in the world. So I can assume that they are in knowledge of all technical issues regarding cryptocurrency, Bitcoin, blockchain transactions. I have not studied this. I'm just a user and just guiding, or not guiding, just using this until this time for my own things. And then to set up according to the device, which led everybody, not only me, through this process to set up something. But this is not that I am a cryptocurrency expert.
And it's been suggested by the claimant that you made various representations at this meeting on the 16th of December. Now, I'd just like to go through them with you. The first one is that it's been suggested by Ms. Stewart in her questioning of Dr. Ahmadi that you had told Dr. Al-Ali in the 16th of December meeting that you had provided crypto custodial services for clients in the past. Now, that's not correct, is it? Because you have never done that, have you?
That's not correct. And a lot of this, what I hear the first time in this trial, I was shocked what these people are talking about.
Well, I think you've answered the question. You've said it's not correct. And that's
yes.
For evidence. Yes, go on.
Thank you. The other representation said to have been made by you is that you told Mr. Al-Ali at the meeting of the 16th of December that either Narvacon or Mr. Morozov were clients of TABARAK. Now, pausing there a second. Mr. Al-Ali has given evidence, and you may have heard it because you attended trial, that as early as 3rd of December, the buyer told him that he had an account with TABARAK. Can I also ask you to turn to Mr. Al-Ali's witness statement? It's at page 612, paragraph 37. Do you have that there?
Yeah, the outcome of the meeting was documented in the email proposal sent by Mr. Turner. Yeah.
Yes, and if you go first, second, third, fourth line into that paragraph towards the end, but I recall that Mr. Turner said that 2 accounts would need to be opened with TABARAK, one for HUOBI and one for HUOBI's own client if HUOBI was bringing the buyer. You see that there?
Yeah, I see.
Can I also ask you to turn to section 9367, please?
Just a second. I have it, Miss Bushra.
Ahmed, Miss Ahmed.
Sorry, Miss Ahmed. Sorry, my
okay.
bad.
So 9367 at the bottom there, where the entry is 11:53, and nothing turns on the timing, by the way, it's just by way of reference. 18th of December, which is 2 days after the 16th of December meeting, everything is by reference to Mr. Morozov, is it not? Is saying, good, so for now we're waiting agreements from TABARAK, and you'll be ready to do proof of coin, and after I'm preparing dollar and euro sign. So the first question is that it's right, isn't it, that your understanding that Mr. Morozov or Narvacon was a client came from Mr. Al-Ali, didn't it? Because he must have told you that at the meeting of the 16th of December.
Yep.
And is that the reason why you note it in your email of the 16th of December at 8:89?
Just in content to all of this, it shows that they are discussing to each other the terms and conditions, which were then finalized in the email. Yeah, that's my understanding.
Yes. So my question is, where you say, or where you perhaps refer to that Narvacon or Morozov was a client of TABARAK, it's in fact information that's being given to you by Mr. Al-Ali, isn't it?
It's not this way, because it's also the same what is with HUOBI. In the deal structure, it was our conditions, they need to become client. That's it. But they have not been client because they did not fulfill. And finally, as I stated already, the most important point is they did not follow what they agreed. They changed on the very last day. But as they are buyer and seller by themselves, okay, Yeah, but anyway.
Yes, so it's been suggested that you represented to HUOBI that either Morozov or Nabokov was the client, and I'm suggesting to you that you did not, did you?
I did not do this.
Right. And if we go to 8...
And one more, Mrs. Ahmad. Morozov showed them on the laptop the account. They know each other. And this is for me so non-understandable. Now I should have been done everything. How can I do? They were together. They were before together. They wanted to make deals. They showed the statement to each other. And then they wanted to use us. And I don't want to make a conclusion what this is for me. But this is another decision by somebody else, which will come later.
Yes, and we'll come back to this bank statement showing point that you've raised in your evidence. But just dealing with the representations, it's also been suggested that the third representation you made at the 16th of December meeting was that you told Mr. Al-Ali that the buyer had money to pay for 300 Bitcoin and that he could provide money to Tabarak, and that money was held in a local bank like Dubai Islamic Bank. Did you or did you not make that representation?
I did not. They made it by themselves and they reviewed by themselves.
And it's also been suggested, representation 4, that you said at the meeting of the 16th of December that the buyer was representing a group of Russian investors. Now, it's right, you would not have known that, would you, if the buyer and seller were discussing amongst themselves about this deal?
Yeah, because Mr. Morozov was stating, and also this was always the question, who are the technical and the experts on both sides? Mr. Morozov was representing Alexei Sochin as the representative and IT person from the group behind him. The same what was on the other side, the OTC trader, Mr. Sushant. So yeah, this it is.
And can I ask you to open, please, 8-575? You have this document here?
I have it on the screen, and I have also the... Yes.
Thank you. Just to give a bit of background, so you said in your evidence in response to Ms. Stewart that you resigned on the 19th of February, and then you were, Mr. Ahmadi kept you on his visa because he wanted you to assist with what had happened and trying to sort it out.
Yeah, and also I wanted to have everything clear, because really I felt like raped, and this was yeah, and there will be some actions against Morozov and Navakon. But this I will do on my own then.
Yes, okay. Let's stay focused on this. Ms. Ahmed, go on.
Thank you. And in that context of assisting Tabarak, you were asked to provide your responses to the particulars of claim that had been filed by the claimant.
Yeah, for your understanding, I did not have any device. I did not have any document. How should I do something? So we were in discussions with TABARAK and Mr. Malik, I guess 138 questions.
Yes, Mr. Werner. So this is the document where you respond to, when I say the particulars of claim, do you understand that that's the document by which the claimant filed its case in the DIFC courts?
Yeah.
So, yes. So this was in response to the particulars of claim. And the paragraph numbers here correspond with the relevant paragraph number in the particulars of claim.
Which paragraph?
Well, we can take this in stages. So if you look at 8-575, and this is by way of example, that's the page number.
Yeah.
And I don't know if you're working off hard copy documents on the computer, but if you are, if you can keep 8-575 open and maybe have the particulars of claim open as well, which is yeah.
This was the worked out answers what we had and what was my recall and what was my input then also. Yeah.
So 2-6 6 is the start of the particulars of claim. That's the provenance of the document. And if we look at 5.1 of your response, that's 5.12, paragraph 5.1 of the particulars of claim at 2.7. Yes?
Yeah.
Yes, good.
Now, just coming back to this, the questions that I was asking you about the representations made and so forth, if you turn to 8-576, yes, maybe I should have done it the other way. I think let's go to the particulars of claim, paragraph 8, which is on 2-9.
Sorry. Okay, I have it on. You mean on 19th of January then?
Mr. Thaner, I can't hear you, I'm afraid.
On the 19th of January then, you mean this?
Dated the 19th of January. Yes, it's the.
Yeah. Okay, I have it on the screen. Yes.
Yeah. So the very first version of the particulars of claim, this is a response to that, and thank you for pointing that out. So if you look at paragraph 8, section 6, subsection 6, the first defendant, it's been said by the claimant, the first defendant will transfer the funds standing in the claimant's account with the first defendant to any account nominated by the claimant. You see that there?
Yes.
And you say at 8.6, 8.576, yeah? No, defendant would transfer the funds from Russian party account to supposed claimant's account.
Yeah, as I told you, several changes took place, and finally we had then a final agreement, but there was always something before. They wanted to have this, then the other party declined, then it was back and forth discussions and so on. But then we had in principle a clear and clean structure, what they set up and what we should assist to overview.
Understood. Now, can we go to the account open agreement, please? The draft account open agreement. That's at 8-95.
Yes, I have it on the screen.
Yes, and we've seen we've seen the standard template when Mr. Malik was giving evidence. This agreement is your modified version of the template agreement, the draft template agreement, isn't it?
Yeah.
And you drafted this and amended the standard agreement after the 16th of December meeting, didn't you?
Here I have to come back a little bit to you because the agreements were like supervisioned by Mr. Malik, and then it was brought to a final draft, and this was done then by our department. Yes.
Now, this captures your understanding, doesn't it, of the services that you thought you'd been asked to provide. That's right, isn't it?
I mean, this is the standard template agreement where just asset management and all this. And as I said, it was redone by Mr. Malik according to this verbiage, what we have here now.
Just listen to the question. This was your understanding of the services you thought that you were being asked to provide.
Correct,
and it was
yes.
Services in relation to advising on the security of a BTC transaction, was it?
Oh, it's just this service is what here in. And the most important point is asset management.
Right. And it was nothing, you did not think that the services that you were being asked to provide was in relation to holding Bitcoin.
No.
Rather, let me put the question differently then, Mr. Thurner. You did not understand, did you, when you came to draft this agreement, that HUOBI was saying to you that we want you and or TABARAK to advise on the safety of the Bitcoin transaction, intended Bitcoin transaction?
This was never part of any discussion because it was always clear that HUOBI knows what they are doing.
And therefore it's right, isn't it, that in your mind, you nor TABARAK took any responsibility for this transaction?
Sorry, again, please.
In your mind, when you were drafting this agreement, you nor TABARAK was taking any responsibility for the intended sale of the Bitcoin, were you?
No, at this point, no.
Or at any point?
No, nothing. It was not in the intention that we will carry out crypto deals or something like this.
And even on the 3rd of February, at no point did you, nor did you represent that TABARAK was taking any responsibility for the intended transaction, did you?
For this intended, no.
And nor was it expressed, was it?
It was not expressed, correct, yeah?
And nor were you asked to take any responsibility for the action?
I would not, for this, it was not possible to take any responsibility because as the buyer and the seller agreed, and then finally even the buyer and the seller exchanged in the very last moment some of the major topic points of their agreement.
Can I ask you to turn to Schedule A of this agreement? It's at 8-100. Now, we know as part of the evidence that HUOBI signed this agreement on the 20th of January 2020.
Yeah.
Nobody ever came back to you, did they, asking for any clarification of this Schedule A, did they?
No, it was very clear for everybody. Yeah.
Can I ask you to turn to 8-59, please? -59, and you've said as part of your evidence that compliance and due diligence was an important obligation under the account opening agreement.
Correct, yes.
It's right, isn't it, that on or about the 17th of July, Mr. Malik, the compliance officer, sent you this list of what was required in order to comply with due diligence obligations?
Yes, that's the standard requirement in DIFC for opening an account with a DIFC entity. Yes.
And this had not been complied with, which is the reason why on the 29th of January, Ms. Avialova sent this compliance email on 29th of January 2020, sent the compliance email to HUOBI, didn't she?
Correct.
And this corresponded with you giving the invoice for the account opening fee on the 29th of January, didn't it?
Yeah.
And I can take you to that email, but it's right, isn't it, that all the documents that were required to comply with the due diligence requirements had not been provided by HUOBI, had they?
I would not say that not all documents. There were some documents they were provided. Yeah, that's just for clarification.
Yes. Okay. Well, let's go to that email. 849.
Otherwise, we would not have the possibility to run a world check on them.
Right. Can I ask you to turn to 8492, please? Sorry, 8490.
Yes, I have it. An email from Mrs. Savialova
Yes.
to Mr. Sushant. Yes.
Because it's right, isn't it? On the 29th of January, you met with Mr. Saxena and you provided him with the invoice for the account opening fee, didn't you?
This email was sent from Mrs. Savialova, yes.
Yes, and
But
you.
it's all of the details what should be fulfilled by HUOBI. Yeah.
Yes. And because you met with Mr. Saxena on the 29th of January and you gave him the account opening invoice, didn't you, for the fee?
Yes, correct.
And on that occasion, you would have said, look, you also need to provide.
Sorry, may I interrupt you? They already had before the details to send the account opening fee, because we were, I guess, 1.5 or 2 months, they were stating that it is transferred from US account of HUOBI, from somewhere HUOBI, from another entity, and so on. It was never done. And then we made very concrete on the 29th, and even when I was in Russia on holidays, yeah, had discussions with Dr. Ahmadi, and there we decided we will give them a real shot to inform that we are stepping out of this business if they don't comply and if they don't go ahead.
Right. And therefore, when everybody turned up on the 3rd of February to conduct the transaction, it's right, isn't it, that there was no written effective agreement in place?
In principle, it's correct. The main issue was missing, number one, as I always stated, the payment, and second, they changed all of the topics of this deal, what they agreed before.
Yes, and you also say that at 8-575, these are your response to the particulars of claim. 8-575.
Yes.
Yeah. 8575, yes, and this is in response to paragraph 6 of their particulars of claim, where they say, when I say they, the claimant, on or about the 17th of December, the claimant and the first defendant entered into an agreement entitled the Asset Management Agreement and Account Opening Agreement.
Yes.
Same response, but claimant never transferred the account opening fee, the claimant never provided all necessary due diligence, therefore no client-bank relationship entered into force.
Yes.
So it's right, when everybody turned up on the 3rd of February, it's right, isn't it, that there were not a client and there was no effective agreement pursuant to which any services could have been provided?
This can be correct as a statement, yes.
And can we turn to, please, 8-316?
I have it on the screen, yes.
Yes, this should be the so-called second deal structure.
December.
Yes, 20th of December.
Yeah.
And it's right, isn't it, that essentially what you were again doing there is putting into writing terms that had already been agreed between the buyer and the seller.
Yeah.
And on the 24th of December, 4 days after this email, there was a proof of coin transaction. And at the time you were in Austria, weren't you?
On the 24th?
Yes. There was a proof of coin transaction. Yeah. You sent an email saying, oh, sorry, WhatsApp message.
Yeah, this was this 0 point something, yeah.
Yeah, and at no point during that proof of coin transaction were you advising on it, were you?
No, they just wanted to prove the address. That's all. Yeah.
Yes, and beyond wishing them
and that it works vice versa, preparation for a deal. That's all.
Yes, and beyond wishing them good luck, in fact, you did nothing more than that.
as it was concluded between the parties, it should be used. And this is what is so strange for me. This is used with the device of us. And then they're coming with an own device. I mean, absolutely non-understandable what this should be. And as I said, I have my own meaning in the meantime about this, between these two parties.
Next question, please.
And the next time you meet is on the 15th of January, isn't it?
Yeah, because I was on holidays and so, and yeah, I guess, definitely, yeah.
Yes. If we can go to 8421, please.
The very specific email, yes. I don't need the hard copy. It's this way. Yeah, thank you. Guess I know it already without looking at.
Yeah, sorry, I'm just bringing my copy up.
I have it, yeah.
Yes. Now, and again, it's right, isn't it, that what you were doing in this email was simply noting what had been agreed between the buyer and seller, weren't you?
Correct.
And it was put to you by Ms. Stewart that what you were doing in that first bullet point was that you were telling and representing that TABARAK has verified funds in a correspondent bank on behalf of the buyer. And you said no in response because they had shared bank account details. You also referred to a UniCredit account and that in fact the buyer and seller had shown each other bank account statements. Now, just so that you know, Mr. Thurner, this is the first time that that evidence has been before the court. It's not in any of the witness statements. It's not in any of the oral evidence that the witnesses have given. So can you tell us a bit more about that, please? Firstly, can you tell us, number one, how many times were the bank statements shown to each other? To whom were they shown? And when?
So, as I recall, the one what I know absolutely was at this meeting, because Morozov wanted to make everything really convincing HUOBI that everything is okay. And he showed on the laptop of Alexei Sochin.
So are you talking about
he showed the bank, the account. And there on the account was the value of about 50 million euros. I don't recall exactly the figure.
Right, pause in there.
But they must have been also exchanged financial informations before, because they went, as I heard then on a trial, they went to Burj Al Arab for making a deal. They wanted to do another deal. So how can it be done when HUOBI don't have informations about financials, when they always insist money first and this and this?
Yes.
I'm sorry. Yeah.
Quite all right. Okay. Just let me intervene for a moment. What you actually saw, rather than the inference you draw having listened to the evidence in the trial, what you actually saw was that at a meeting, information, bank statement on a screen was shown by the Russians to HUOBI.
Yes, Your Honor, by Mr. Alexei Sochin. He went online, log in to the account of UniCredit and showed to the parties the actual balance of the account.
Yes.
But my understanding was nobody was really very impressed or something like this. It was just like normal.
All right.
Even, yeah, so for me it was clear that they exchanged by themselves something, yeah?
Fine. So now what meeting was this? Was this the 3rd of February? The day of the deal? The day that things were transacted, or was it at an earlier meeting?
No, it was on the 3rd before the deal started.
Yes.
Yeah, but I don't know exactly when, but there was no transaction of coins and nothing. It was before the deal started.
Yeah. Okay. Thank you.
Yeah.
Okay, so if I understand you correctly, what you're saying is that before the deal started, on the 3rd of February, Mr. Alexei Sochny, who was the buyer's associate, opened up his laptop, logged into his UniCredit Bulgaria bank account, and showed a bank statement which showed about 50 million euros in that, on that statement.
Yeah, not the bank statement. He showed an account which is under Navarcon, and that there is 50 million, something about 50 million, as I said, not exactly on the account.
And you also said that HUOBI, and who from HUOBI, Mr. Al-Ali and Mr. Saxena, both of them, was shown this bank account?
He showed to everybody in the room the laptop, because he turns the laptop and showed it. Yeah.
And you said that they weren't impressed. So are you inferring from there that they must have seen this bank account previously?
As I said, my impression when I recall it is that everybody knew already what it is, and I don't know why he did it again. Yeah, also Mr. Morozov or Mr. Sochin, why he did it again. Yeah.
Now, it's right, isn't it, that all along, we've heard evidence of this, that Mr. Al-Ali's condition was that money ought to be paid before the Bitcoin was transferred. So is it right to suggest, therefore, that Mr. Al-Ali saw proof of funds, and it's because of that he then agreed for the transfer of the Bitcoins?
Yeah, he showed also that the coins in parts are on wallets with him. That was the next thing. Yeah, I mean, I was like, okay, sitting there and looking what they are doing at the beginning, and then when the the device showed up, yeah, then I started to act according to the wish of the two parties. Yeah, that's all.
Yes, but Mr. Thurner, what I'm saying to you is this, that all along it was a condition of HUOBI that, and questions were put about the standard procedure, that the standard procedure would be that money would be there and then the Bitcoin would be transferred. And what I'm saying to you is, because you were there at the meeting of the 3rd of February, that is it the case that when Mr. Al-Ali saw this bank statement, bank account with 50 million euros in it, he agreed for the Bitcoin to be transferred before any money, before payment?
As I already stated, they were so desperate to do, and according to this, they proceeded. I guess they would have done everything on this day. Your Honor, may I ask how long will it take the questions?
Do you want a break?
Just for 2 or 3 minutes.
Okay. Certainly. We'll take a 3-minute break.
Yeah, I'm coming immediately.
Right.
Yep.
Okay.
Thank you.
Yep. I'm stopping the clock.
Thank you, Your Honor.
Thank you very much. Ms. Ahmed?
Yes.
Right. Thank you. Thank you. Take it, everybody. Take it easy. Off you go, Ms. Ahmed.
Thank you. And so it's right, isn't it, that this transaction was carried out with the express agreement of Mr. Al-Ali, knowing that there was no money in TABARAK's bank account?
It was carried out between Mr. Al-Ali and Mr. Morozov, knowing about the details and everything, yes.
Yes, and in that context, can I ask you to turn up 9-35, please?
Yes.
And these are
I'm on it. Yeah, sorry.
On it?
I
Good.
have
Yeah,
it.
okay.
I have it. Yes.
Good.
So we're on 9-35, and if we go to the bottom there on the 3rd of February, and I'm looking at the entry at 11:05, these are WhatsApp messages between Shantanu and Mohit. Mohit's asking, morning, it's good we finally closed an OTC deal. Did the process go smooth? And Shantanu responds, coins are still with TABARAK. We're waiting for them to transfer the funds. Shantanu, the process was not too complicated. They were flexible on a lot of things. Over the page 9-36. Why haven't they done the wire? Russians have released the funds on the European side. TABARAK is waiting for funds. That was all supposed to be done an hour ago. I thought we were not going to do the deal with TABARAK had clear funds in their account. This was my understanding too. Initially, they said that the money will be paid straight away, but later after the coin transfers, they said that the wire will be done by 2:30. Sultan was with us throughout. He agreed the process. We should be fine. Give us some time. Mohit, that's very risky. We shouldn't have agreed to this at all. This was a firm condition that Sultan had agreed with them. Let me ask him why the change. And it's right, isn't it? The change was because Morozov had shown his bank account or a bank account from UniCredit Bulgaria, which showed 50 million in funds. That's right, isn't it?
I can just say I suggest yes, because of this. But it shows also that they know each single point of the transaction, what was always agreed between these two parties.
Yep.
And it's,
Go on, Ms. Ahmed.
it's right, isn't it, that on the day of the 3rd of February, all TABARAK was doing was providing a neutral venue for the transaction, nothing more.
Yes. And one thing more, honestly, it was like a little bit of rent agreement or whatever you can say. When you have a look at the fees and all this, I mean, it's incredible. Out of those amounts with those figures, and also this shows that this was not a deal of TABARAK. It was a private deal between these two parties where we had to be, let's say, yeah.
And it was suggested that you provided assurance that to the HUOBI team that they ought to transfer the BTC because it would be safe. Did you give that assurance representation?
No, that's what I said. I never stated all of this, what was coming, 5 or 6 sentences. I assured this, I assured this, I assured this. How can I assure it when they do a deal to each other?
And if I can ask you to turn up your witness statement, please, your 8th witness statement. It's at 7:52. Sorry, 7:53. Paragraph 15.
Yes.
You say there, and this is, I think, as to paragraph 76 of Mr. Al-Ali's first witness statement, you say, I did not tell Mr. Saxena and Mr. Al-Ali of the claimant that it would be safe for HUOBI to transfer the BTC into the wallet before the buyer had made payment, or that BTC would be held in the wallet, which would be kept in TABARAK's possession, and it would therefore be safe. Further, I did not at any point state that TABARAK had checked that the buyer had sufficient funds in Dubai to complete the transaction, which the buyer knew to be about $2.8 million from the WhatsApp messages I referred to above. And then you go on that you didn't say, Mr. Turner assured me that there was no reason to be concerned by the use of the buyer's wallet. This process, including the timing of the transfer and the use of the 12-word seed phrase, was proposed by the buyer and the claimant expressly agreed. And that's right, isn't it?
Yes, Ms. Ahmad, as I stated several times to Mrs.
Stewart.
Mrs. Stewart.
And if you can turn to paragraph 26 of this witness statement.
Yes.
You say there that the issue of whether the buyer's Trezor wallet was to be used by the BTC transaction only concerned the claimant and the buyer. I did not advise the claimant to use it or volunteer to set it up. I set up the buyer's Trezor wallet only upon the proposal of the buyer and with the consent and agreement of the claimant and the buyer. I did not say to Mr. Saxena, I did not have any concerns in using the buyer's wallet, and I did not reassure him by saying that he would set up the wallet and that once the Bitcoin was transferred, into the wallet would be placed into Tabarak's safe, which only Mr. Turner and Tabarak's CEO, Mr. Ahmadi, had access to. I did not give him any assurances. I was merely there to execute the transaction based on the instructions of the party. For the avoidance of any doubt, I did not have access to Mr. Ahmadi's safe. And that's right, isn't it?
Yes, and we go over and over and over and over again about the same questions and the same.
Well, yes, and we've had this actually, frankly, Ms. Ahmed. This evidence has been consistent with what he says in this paragraph.
Right.
And I'm not sure it was really necessary to go to it, but never mind. Let's move on.
You also said in evidence in response to Ms. Justina's question, Ms. Stewart's question, that Saxena had tried to put a stop to the transaction, but he was overruled by Mr. Al-Ali.
Correct, and you see it according to the WhatsApp messages too.
Yes, Mr. Saxena has given evidence that he knew that there was a risk that if the buyer brought his own wallets and that they would be used, that there would be a risk that the Bitcoin would be stolen. He's also given evidence that he was aware that there was a mechanism by which one could scroll up and down the wallet. Did he say anything about any of this during that meeting on the 3rd of February?
No, there was no word about stolen or something. It was just from my side where I said, we should use our device, but when you set up, it has to be agreed by you both parties. I'm out of anything, yeah. And Tabarak is nothing, not even here in some other issues or some other capacity. They changed everything, as I said, and this is incredible, yeah.
And in response to a number of questions by Ms. Stewart, you said that the device leads you through the process, and that's the Trezor wallet device. But it's right, isn't it, that the setup is designed for a single user, not for a double user?
Sorry, once again, please.
It's right, isn't it, that the setup process is designed for a single user, but on the 3rd of February, what happened? There were 2 users, you and the buyers.
A Trezor is normally used by an institution or a person, and that's it. It's not used by 2, yeah.
And in fact, it was Mr. Al-Ali who volunteered that you ought to be one of the persons setting up the wallet as well as the buyer.
They wanted me to run the setup process, yes. Both of them, buyer and seller.
Now, coming back to your meeting with Mr. Saxena on the 29th of January.
Yeah.
It's right that you met.
Which paragraph or what or where?
Well, I can take you to your paragraph. Well, you don't really deal with this in your witness statements.
Okay, sorry. I thought just you. Okay, fine.
So on the 29th of January, you've already accepted that you met with Mr. Saxena, and that was to give him the account open invoice and to tell him that actually the compliance obligations needed to be complied with.
Yeah.
Now, claimants say that what was discussed during the 29th of January is that the commission would be deducted from the proceeds of the transaction. I'm going to suggest to you that that's not right, is it? There was no conversation about commission or deduction thereof.
I cannot recall on the 29th, but definitely on the 3rd of February before the deal, it was agreed finally then, as Dr. Ahmadi was in, that it will be deducted from the incoming amount to the account.
Right, well, let's just think about this again. I want you to think about your evidence, Mr. Thurner, because when everybody turned up on the 3rd of February, the only reason, well, there was no effective agreement, you've given that evidence, and they were not a client, HUOBI was not a client of Tabarak, and the only reason why they turned up to that meeting was because they thought, and everybody had agreed, including you, Mr. Thurner, that Tabarak was to be used as a neutral venue. So if that's right, there's no basis, or there would have been no conversation, though no need for a conversation about whether or not commission should be paid. That's correct, isn't it?
Here, can you, I mean, you are saying that there would have been no need to discuss any commission then, or what?
Well, let me take it in stages. Let's first start with the particulars of claim and what the claimant says. If you go to 2-13, sorry, 2-10, paragraph 13. Yes. Yes?
Yes.
Paragraph 13, on the 3rd of February, claimant and the first defendant agreed that the first defendant's commission for facilitating the transaction would be 0.25% of the said price. You see that there?
Yes, I see it.
And you accept, don't you, that there is nothing in there about whether or not the account opening fee will be deducted? You accept that?
So in this, has nothing to do with the account opening, yes?
Right. So let's go to your response to this paragraph 13. It's at 8576. Yes?
76, yeah.
And you say, in response to point 13, unequivocally, not correct. Those 0.25% were related to continuously business transactions offered from claimant, but having no corresponding relation to the herein described supposed transaction, and never happened, although several times announced by claimant, because we insisted to having payment for the account opening fee and to be fully onboarded as a client first. You then go on to say, in response to paragraph 14, which again talks about what happened at the start of the meeting, yes, however, Dr. Ahmadi simply met by saying hello to all the parties and was not a party to the meeting whatsoever. Now, this response is given on the 29th of April, 2020, so very close to transaction. You accept that, don't you?
Yeah.
And so if one is to rely on this response, it's right, isn't it? That number one, there was no conversation about commission. And number two, there was certainly no agreement that 0.25% would be paid out of the proceeds of the transaction with Dr. Ahmadi present. That's right, isn't it?
This I cannot confirm in this way. An agreement, or let's say something had to be, of course, otherwise Dr. Ahmadi would not allow to use the office. That's number one. But it's absolutely correct that it was not fulfilled that we have an agreement, and it was not fulfilled to go ahead with the procedure which the two parties agreed to, and we had to maintain.
Right, but in terms of using...
And the rest, just to be clear, I don't know, as I said, what they were talking in Arabic, but in English, it was not mentioned something. It was only then that regarding the deal and regarding that success, it should be a successful transaction. And so that finally all of this regarding the client to become client for all of the parties would be fulfilled, and that we will have a great future transactions in this, because 3,000 Bitcoins, you know, is something really with a quite big figure. And then there would be a real good earning out of this.
Ms. Ahmed, this witness has said, as clearly as can be said, that Dr. Ahmadi, during the short meeting, that gathering, if you like, before leaving and letting the transaction proceed, agreed that the account opening fee could be dealt with by reference to the proceeds of the transaction. Moreover, this second defendant's counsel suggested to, it was Sultan Al-Ali, that this is what happened at the meeting, and he did so clearly on the instructions of this witness. Now, what that means in your case is that you either put to this witness that he is deliberately telling a falsehood here, or you have to accept his evidence, it seems to me.
Mr. Thurner, I'm going to suggest to you that given the responses that you provided very close to the transaction on the 29th of April, that in fact those responses are correct, and what you are saying now today and what your counsel has said on your behalf in these proceedings is not correct. That's the true position, isn't it?
Sorry, that's not enough.
I cannot comment this.
Wait a
what you are
moment,
talking.
please. Ms. Ahmed, you haven't, you've not grasped what I put to you. You are obliged to put to this witness that he is deliberately giving false evidence on this matter.
Mr. Thurner.
You can't simply say that it's incorrect.
Mr. Thurner, in accordance with the judge's directions, I'm putting to you that in fact what you are now saying is not true and it is a falsehood.
What shall I say?
Well, you say yes or no.
I am telling you what was, and also maybe just for your clear understanding, even I could have maybe forgot some small issue, and when this is a big issue for you, then I don't know what really is in this deal the necessity. I'm so sorry for you.
Well, I take that as a straightforward denial that this.
Correct. Yeah, I decline fully what Mrs. Ahmad is stating here.
Yes. Yes. Right. Now, there must be other topics. Let's go on to them.
Yes, and so I suggest to you, however, that if there was any agreement for the payment of commission, then that was a private agreement after the transaction took place, after the Bitcoin was transferred at around 1 o'clock between you and HUOBI. That's right, isn't it?
Sorry, once again, what should be between me and HUOBI?
The payment for commission. It was on your personal account and in your personal capacity that you agreed with HUOBI that commission ought to be paid, and that commission would have been paid to you.
And now I have to state the same way to you. If you mix the test session with this, what happened on the 3rd, then I have to say that you are stating to me false facts and false document. This what was paid to my account was the testing session of 2 Bitcoins and has nothing to do with any commission.
Now, you turn to
and you know it exactly. You know it exactly.
Can you turn to 8-278, please, Mr. Thurner?
Incredible. Yeah. I mean, this line, we have a lot here. What is 8 something?
8-496.
F4.
And this is an email from Saxena to you, copying in your assistant and Mr. Al-Ali and Mr. Nahak, 1335. And the deal, the transfer was conducted at 1306. Hi, Christian, please find attached the trade details for the first 300 coins. Now, Dr. Ahmadi is not copied into this email, is he?
No.
No. And the reason why he's not copied into this email, because after the transaction happened, you in fact agreed with HUOBI in your personal capacity that commission should be paid to you directly.
Absolutely incorrect.
Now, and the reason being is because Mr. Ahmadi has prohibited you from conducting any transactions with HUOBI, and he did so on the 27th of January, didn't he? 28th of January, sorry.
This is also absolutely incorrect, and I can, yeah, if the honor gives me some time, I will explain you correctly now again what happened in regarding this deal.
Yes.
We had a test session. Of course, as I stated, TABARAK was really desperate also to do some deal in this new world. So there was clearly a discussion with Dr. Ahmadi regarding how we could do according to DIFC and DFSA rules. And so that's why then OCS International was set up, and to have an agreement with HUOBI, so that here out of the box, something on so-called transactions could be done. The deals themselves was in principle made to help HUOBI with EMAR real estate. EMAR real estate, they had a lot of clients where they wanted to pay with Bitcoins. And as HUOBI had no account here, this was one part of beside a business and had nothing to do with the deal of the 300 Bitcoins. But everybody here is mixing. And this should then happen, that Bitcoins from clients coming to OCS, OCS is sending to the exchange of HUOBI, and from HUOBI, yeah, money should come to TABARAK, and TABARAK is refunding OCS then for the client, yeah, and that's the situation. And this has nothing to do with the 300 Bitcoin deal.
So if all of this is to be accepted, then why did you not put it in any of your witness statements? You've given 8 witness statements in these proceedings, Mr. Ferner.
The witness statement is related to the 300 Bitcoin deal. Until now, nobody asked me about the testing session.
No, I'm talking about...
And what it was for. And also, when you are stating this, a lot of information regarding from Dr. Ahmadi, I don't know what digital assets are, and so on, yeah? I leave it open what it is.
Yes, but I'm talking about the commission payment and the agreement. None of
the
that.
Commission payment is not to me personally. It is going to the account of TABARAK.
That's the question. None of that is covered in your witness statement. And the reason why it's not covered is because you're making it up as you go along.
As I said, absolutely incorrect. And once again, commission and all. And in every time, everything had to be paid to TABARAK. Even the money from HUOBI which came and then it has to be refunded, had to be refunded to OCS. It came to TABARAK account.
Can I ask you to turn to 8485, please? Yes.
You've got about 5 or 6 minutes more, even with me having added on.
Thank you. Hopefully I'll try and round this up very quickly.
Yeah, okay, good idea. Yeah.
Answers. The chain of email starts at 8486. Yes. Yeah.
Yes.
It's an email from you on the 26th of January. You copy Dr. Ahmadi into it. Now, you also copy in Mr. Qadir Khan. At that time, Qadir was the finance director, wasn't he?
Yes.
And you were very friendly with Qadir Khan, weren't you?
In the meantime, yes.
Yes. And he is now employed by your company, OCS, in the DIFC,
Correct.
isn't he?
Correct, yes.
And 8-485, on the 27th of January, Dr. Ahmadi says to you, having realised that you're providing services, hi Christian, I believe HUOBI is not a client yet, and I'm wondering how you're providing services without becoming a client. Do you see that there?
I see it, yeah.
And he has a discussion with you, doesn't he, around about this time, saying to you that while you're providing services, you ought not to be because there is no account open agreement. That's right, isn't it?
We had for sure several discussions. If it is a discussion as you stated right now, I cannot recall and not reconfirm, because finally it was a testing session regarding not the BTC deal of 300, it was regarding the regular business with EMAR and HUOBI and clients of HUOBI, which should open vice versa accounts with us and with HUOBI.
And if you look at the top of this email chain, 8-485, you say, testing session. When I am back, I have meeting with them being HUOBI, and then also we will have the account opening fee. So as part of your several discussions with Dr. Ahmadi is insisting, isn't he, with you, do not provide services unless we have an effective account opening agreement and unless they're onboarded as a client.
Yes. Yes, and we were told by HUOBI several times that the account opening fee is on the way, as I stated already.
And that's why you copy in Dr. Ahmadi, because you're trying to, into this email, because you're trying to pacify him, aren't you? You're trying to give him the impression, look, I'm following your instructions, aren't you?
You are suggesting, or is this what it is?
It's what it was, wasn't it?
No, it was not. You are suggesting.
You were also assuring and giving the impression by this email that, don't worry, Dr. Ahmadi, I'm not going to provide services until I have an effective account opening agreement.
Again, is this your suggestion or is it?
No, what's being put to you is that this is what...
But it is not, Your Honor. It's not true.
No, fine. That's for you to say.
Yeah.
It's being suggested to you that this was... you had a particular motive in sending this email.
Okay, it's not true.
And of course, it's open to you to respond, and your evidence is that it isn't true. And the transcript will show that.
Then we go to 8-484, which is the last email in this chain of emails. And just taking this in stages, Christian, we discussed this client in my office last time. And you mentioned that we'll do a test transfer, and I did mention to you that they need to be a client and pay the account opening fee in order to do all jobs for them. You see that there?
Yeah.
Now, when Dr. Ahmadi is saying there, we discussed this client in my office, you've given evidence that there were several discussions about HUOBI, wasn't there?
Yes.
And if I can ask you to turn to 8-472. Those several discussions involved Mr. Ahmadi telling you that we will not provide any services in the absence of onboarding HUOBI as a client. Didn't he?
Yeah, this was always the discussion, yes.
Yes.
But not only this.
And he also told you, didn't he, that we aren't going to provide any services related to crypto, which is why you say that halfway down this email, we don't do for anything related to crypto. You see that there?
Yeah.
And that arises out of a discussion with Dr. Ahmadi, who tells you to tell HUOBI this, which is why you write this email to them.
Sorry.
Yes?
Yeah. A group compliance and a yes.
Right, that's better. Sorry, we couldn't hear you then.
Yes, it was in this last sentence. It says, hopefully you understand on my email to Mr.
We've lost you again.
Yes, Mr. Turner, when you turn your head to look at the screen,
sorry,
you lose your voice.
Okay, wait. In this email, yes, in the last sentence, it's very clearly stated that we are a licensed and regulated bank located in the IFC. And this must be far more than enough for you crypto guys to have compliance issues done. Yeah.
Yeah. And so the last sentence, please note and take this for final, capital letters, exclamation mark, because Mr. Ahmadi has told you, hasn't he, in no uncertain terms, look, we're not providing these services unless we have an properly onboarded client. And that's what you do in this email, don't you?
Not correct, Mrs. Ahmed. It is stating that this must be final on documents when you look up what we are sending. Because we are opening here an account with HUOBI.
Well, that's not right, is it? Because if you were, you would not say in your first sentence, we are not trading anything with you. We are only for service for HUOBI.
Yeah, because we needed to have HUOBI as a custodian service, because we need to arrange for this digital assets custodian, and we cannot do. That's why we had to open an account with them.
Absolutely, you have to open an account with them. And what Dr. Ahmadi is saying to you is, we're not providing any services unless they open up an account, unless they comply with your own compliance and AML department, which is what you say in this last paragraph. And this is why you write this email and copy Dr. Ahmadi.
This is related to the deal, and this is what I stated. They did not pay the account opening fee.
Absolutely. Let's go back to 8-484. And the first sentence that I've read to you, we've already seen that email, is really Dr. Ahmadi repeating his instructions to you, isn't he?
I read this email.
Right, and then it goes on to say they need to mention their account opening reference, and that's all. And I took a note of your evidence that you gave to Ms. Stewart, and what you said that, and it's page 32 of the transcript, look, this is the process. Where there is an account agreement, they will be given a reference code. So when Mr. Ahmadi is referring to an account opening reference, it's actually a reference to there is no account opening reference because there is no effective account opening agreement, isn't it?
I explained already how the procedure was running. We need to give, because as I said, there is no direct account to the client in the IFC. It's always TABARAK is the account holder. Even when using their own account for something to be preliminary, sent like account opening fees or something, there needs to be a reference. Otherwise, it could not be maybe so easy traced to whom it belongs. And that's it.
And what you understood from this email is Mr. Ahmadi saying to you, stop. We are no longer providing any services to HUOBI, which you then conveyed to HUOBI, didn't you?
Not correct.
Let's go to
Mr. Ahmed, I must warn you now, you've got about 3 minutes or so to go. I've already generously added a considerable amount of time to you.
Yes.
But I am determined to finish within the same allotted time. So you've got three minutes to bring your cross-examination to a close.
Your Lordship, you've allocated me about 45 minutes with Ms. Zavliova. I will not be taking 45 minutes with her.
I have that submission, and I have, to begin with, your allocation was 1 hour and 20 minutes. You're 20 minutes over that. I have a stopwatch running. So, well, let's say, all right, don't say I'm unreasonable. You've got 5 minutes to finish this.
Right, I'll be very quick then.
Okay.
9-416. You send this WhatsApp message at 2:57 in the morning on the 29th of February. I have to apologise in the name of TABARAK. Dr. Ahmadi is complaining regarding account opening fees. I'm back from Russia tomorrow. So forth, so forth. You've got the WhatsApp message. And that's as a result of Dr. Ahmadi prohibiting you from engaging with HUOBI, isn't it?
This was, as I explained already before, we wanted to give them a real hard warning that if they don't follow, then the proposed action regarding this exchange and regarding becoming client of TABARAK will fail.
And can I ask you to go to 9239, please? So following this WhatsApp message, you then have a meeting with Mr. Saxena on the 29th.
9239.
9239.
Yes.
So I beg your pardon. Yes. On the 28th.
What you want to know?
Yes. Can we go to 623? What Mr. Saxena tells his team at HUOBI, meeting Christian tomorrow, he called up saying it's not him but Ahmadi who is creating a fuss. He thinks it should be sorted and is keen to do business with us. So it's right, isn't it? Despite Dr. Ahmadi's prohibition, you were keen to do business with HUOBI in furtherance of your own benefit, weren't you?
Yes, as everybody, I was also keen to do the business. Correct, yes?
Yes. And in fact, you then, after the intended transaction, resigned on the 19th. I don't think I need to take you to that resignation letter. Let me just have a quick check. I'll take you to it. 8-531, please. And what you say in that resignation letter,
8-531.
8531.
And what you say in the third paragraph is it's not possible to work here because I brought TABARAK in troubles. And it's right, isn't it? All of this is on you. You brought the HUOBI in, and all of this is as a result of you going ahead with a transaction without any agreement from Dr. Ahmadi.
That's not correct, but maybe you have a little bit of understanding, which I'm not expecting, but after coming out of custody, nobody helping you, being misused, as I stated already, I made the resignation immediately because I really was absolutely in an, I don't know, in a situation, this is incredible.
My final question.
And even being in custody, even being in custody with the criminal Morozov beside me, who was welcomed in the custody like a friend to everybody. I mean, what shall I tell you? And I'm sorry, maybe I made some miswritings or something, but my intention was really, first of all, to resign. Secondly, to help TABARAK with anything what is possible against these criminals. And third, just to have silence and finished. Yeah, that's all.
And my final question, Mr. Thurner, you'll be pleased to know, is relating to the document at 8-577. And what you say is, I would also like to state that as HUOBI did not provide and pay all necessary dues regarding the account opening agreement, HUOBI was not a client of TABARAK. I simply acted on behalf of HUOBI in a personal capacity and was simply following the usage of TABARAK office, and for me to simply overlook the transaction between HUOBI and Russian party. And so it's right, isn't it, that after the 28th of February, when Dr. Ahmadi prohibited you from engaging with HUOBI, you did so in your personal capacity, didn't you?
No, it's your suggestion, and it's out of a content which is absolutely more complex, as you are stating now and trying to set out here. It's not correct.
And what in fact you did there was in breach of your employment contract, your employment obligations, and you were off on a frolic of your own, weren't you?
Sorry, I was what?
It was in breach of your employment conditions and employment contract.
Which kind of breach?
And you were acting in your own interests, weren't you?
This is not correct.
Thank you, Mr. Thurner. Thank you, Your Lordship, for the indulgence. I don't have any further questions.
Right. Now, Mr. Turner, what happens now is that your counsel can ask you, it'll probably be relatively few questions. It's up to him. And after that, that will be the conclusion of your evidence. So I'd like to get that done. I think it'll only be a few minutes, and then
it's no problem. It's okay.
Okay. Well, let's go on then. Mr. Matthew, do you have any questions in re-examination?
Just a few, my lord. Mr. Turner, my learned friend, Ms. Ahmed, said that according to your employment agreement, you didn't have the authority to sign any account opening agreements. Can I take you to 8361?
Yes.
This is the asset management agreement and account opening agreement with HUOBI and TABARAK. And if I take you to page 8365 of this agreement.
Yes.
You have signed this agreement. Can you explain why you have signed this agreement?
Yeah, first of all, there were several situations also when Mr. Ahmadi was somewhere on leave, or when it, I don't know, when it had to be necessary. But finally, the most important point is always the seal of TABARAK, as it was explained also, because this was the holy grail of TABARAK, and it was only in possession of Mrs. Somaye, Dr. Ahmadi himself, and Mr. Khan for financial transactions. So all of this was always under knowledge of Dr. Ahmadi. But I signed it, but don't ask me why or how I had to do it. In a certain kind of position of director of investment, when he was telling me, sign it. And even he told me several times, don't copy me everywhere. It's your job. You have to be on this way, and you just give me the key points. Yeah, but I don't know why his signature, when you want to ask this, is not on the agreement. But executed, it was with invoices. It was with Kadir Khan from the financial department. It was then in the original with Somaye. So everybody knows about this. I did not do anything behind the back of Dr. Ahmadi.
Thank you, Mr. Thana. Can I take you to now 8496, please? Let me know when you're there. Sorry, we couldn't hear you, Mr. Thana.
I'm here. Yes, I have it.
So
8-496.
This is an email that Ms. Ahmed showed you from Mr. Saxena to you, and where he says that please find attached trade deals for the first 300 coins. Can you explain what does he mean by trade detail? Does he mean the price that they had set for the 300 bitcoins?
Sorry, that's a leading question. You're in re-examination.
Sorry, can you explain?
I'm going to permit that. I'm going to permit that. He's asking the witness to explain the document.
Can I answer?
Yes, please explain.
So as we had a WhatsApp group, there was also, this was the structure of the cent bitcoins, because it came in several parts.
And can I show you the next page, the attachment?
Yes.
Which was concerning the first 300 Bitcoin deals. Can you explain the revenue section? How is the revenue section broken down there? Can you tell us, did you personally receive any share from the revenue?
No. Yes, I would have a share out of the fees of TABARAK according to my contract.
And can you explain?
It would be 25% out of these fees.
From the total revenue here in this document, does it show any share of yours?
No.
Okay. And finally, can I take you to page 9239?
9. Yes.
Yeah, are you there, Mr. Thana?
I'm here, yeah, 9239.
So Ms. Ahmed showed you this as well. And Mr. Saxena says meeting Christian tomorrow. He called up saying it was not him, but Ahmadi who's creating a fuss. He thinks it should be sorted and is keen to do business with us. Can you explain who is keen to do business with us? What does he mean by that? Is it TABARAK or is it you?
Oh,
It's all of the parties which are involved. They were keen to do business, but we at TABARAK was also keen to do business to earn something out of this, because you asked me before about the structure, what is the earnings, and out of this value, it was a so-called really nice figure.
And finally, one last document, 8492, please.
8. Yes. It's an invoice, yes.
And this is the invoice for this BTC transaction opening account,
for the account opening.
And can you tell us who was going to receive the payment under this?
TABARAK, on the account of TABARAK Investment Capital Limited.
And who prepared this invoice?
This was definitely prepared by the payment department, by Mr. Khan. Because there's
And-
also the stamp on
and
with
what
the
was the-
tax invoice.
And what is the date of this invoice?
29th of January.
And was Dr. Ahmadi aware of this?
Absolutely. Because everything what happened in TABARAK was aware to Dr. Ahmadi.
My lord, we have no further questions. Thank you,
Thank
Mr.
you very
Turner.
much. Mr. Turner, thank you for your evidence. You're released. You, of course,
Thank you.
are the party to these proceedings to continue to observe what happens. But you're released as a witness. Thank you very much. Now, I think at this point we should take the half-hour break. So we shall resume at 10 past the hour. And I've been given assurances about the length of time of the cross-examination of Ms. Zavilova, and I think we're on reasonable track to finish within the allotted 5.5 hours. So thank you all very much. As we shall resume at 10 past the hour. Thank you.
Thank you, my lord.
Well, I think our 30 minutes are just drawing to a close. Are we all present and correct?
Yes, my lord.
Ahmed, yes. And the
Yes.
witness?
She's here as well, Ms. Zavilova.
Good. Well, now, just elicit her name and address, Mr.
Yes.
Matthews. And
Yes.
I'll do the rest and then you can take her.
Yes. Ms. Zavilova, can you give us your full name and your address?
My name is Anastasia Zavyalova. I live in Dubai, United Arab Emirates.
Ms. Zavliova, as you'll appreciate, I'm the judge. You may have been observing some of this trial. And if you have, you'll know that all the witnesses are required either to take a religious oath or a secular affirmation. The court draws no distinction between the two as in terms of value. Would you like to take a religious oath or a secular affirmation?
Your Honor, I'll go with circular affirmation.
Yes. Now listen carefully to what I'm saying. I'm going to be asking you a question. Do you solemnly and sincerely declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you very much.
Ms. Zavilova, can I take you to 6118, please?
Yes.
Is this your... Are you there?
Yes.
Is this your first witness statement?
Yes, correct.
Can I take you to the last page of your witness statement at 6121?
Yes.
At the bottom of the page, is that signature yours?
Yes, correct.
Please, can you confirm the contents of your witness statement are true to the best of your knowledge and belief?
Yes, I can confirm.
Thank you. Now, the counsel for the claimants and first defendant will have some questions for you.
Ms. Stewart, see if you can get this done in 10 minutes. Let's see how we go.
For obvious reasons, I won't be putting forward, I won't be cross-examining on points that are inconsistent with the case I've already put forward.
Yes.
So I'm just going to focus on a couple of points.
Yes.
First, Ms. Zavyalova, I understand that you now work with Mr. Thurner at OCS. Is that correct?
Correct.
You're his assistant.
Correct.
Right. I just want to ask you some questions about KYC. during the meeting on the 16th of December, the very first meeting with TABARAK, and also in Mr. Thurner's email on that day, what's called the first deal structure email, it was made clear that, or it was proposed by Mr. Thurner, that HUOBI should become a client of TABARAK. Yes?
Yes.
Right. Now, on that very same day, you sent an email. So after the meeting, you sent an email to Mr. Al-Ali, copying in Mr. Thurner, and that's at 8:94.
Okay, it's in front of me.
Great, thanks. Actually, I've got the wrong page, which is deeply unimpressive on my side. Just bear with me. Now, you agree that on the 16th of December, you sent an email to HUOBI saying, providing a list of documents that were required by TABARAK in order for HUOBI to open an account with TABARAK. Yes?
1 second, I need to find this email first.
8:64. Really sorry about that.
Yes, I sent that email.
Yeah, and you agree that that HUOBI sent all of the documents that were requested in that email. They sent them back on the same day. Yes. We can see that at
with the
at 8:63 to 88. There are quite a few documents there.
I requested these emails, these documents, in order to prepare an account opening agreement. So,
yeah.
And you're asked to confirm that over time, HUOBI supplied the documents you requested. Do you accept that?
I sent an email 3:52 requesting the documents. 16:42, they say, please find attached all the documents. And they send it to me. So, yes.
Thank you.
And they also said, we'll send the lease agreement in a short while, and they did do that. Yeah? Okay. Now, do you recall, Ms. Savyalova, that on the 29th of January, Mr. Saxena visited TABARAK's offices, and he met with Mr. Turner and you?
Was he visiting alone? He probably came with Ali, Sultan Al-Ali.
No, this, just to jog the memory, this was the time where there was the toing and froing over the account opening fee. And Mr. Saxena, his primary purpose was to try and smooth over the problem with the account opening fee. Do you remember that?
Everything that I recall, which, like, after 2 years, the memory is not so clear. I only remember the meetings with Sultan Al-Ali and Mr. Saxena together. But this is as per my recollection.
Okay. Now, if we go to now, well, I'll put it to you that when Mr. Saxena visited your Tabarak's offices, he asked for details of what KYC documents Tabarak required from HUOBI clients who wanted to become clients of Tabarak. Do you have any recollection of that whatsoever?
If I was to provide a list of KYC documents, then I would have sent it also by email. Or
Okay.
someone.
So if we go to 8490,
I have it.
okay, so we can say this is an email from you to Mr. Saxena, copying in Mr. Thurner on the 29th of January. I hope this email finds you well. As per the request of Shantanu, so that's Mr. Saxena, yes, kindly find below the required documents in order to open an account at Tabarak. And then you give a list for corporates and individuals.
Correct. This is what I said.
So haven't seen that email now. Do you remember that this was in the context of Mr. Saxena asking what KYC documents were required from HUOBI clients who wanted to become Tabarak clients?
Until now, still having seen this email, I don't remember a meeting with Mr. Sushant without Al-Ali. But this is true that in order to open an account, either corporate or individual in Tabarak, the potential client has to provide this list of documents. And the initial document that I requested, in the previous email is in order to prepare an account opening agreement. So this is less. This is just for the information to insert in the account opening agreement.
And to the best of your knowledge, Ms. Saviolova, it's the case, is it not, that up to and including on the 3rd of February, at no stage did anybody from Tabarak tell HUOBI that it required more documents in order to complete its onboarding of HUOBI as a client? So to the best of your knowledge, was HUOBI ever told by anyone at Tabarak that all of the necessary KYC documents to be onboarded as a client hadn't been provided by HUOBI?
It's not in my capacity to tell the potential client if he's onboarded or not. In my capacity is to send the list of required documents, and then it goes to compliance. And then they therefore decide if they need to provide further documents or not. And then this goes to management.
I understand your answer. So if I'm to understand correctly, to the best of your knowledge, you're not aware of any communications with HUOBI from anyone at Tabarak saying that all of the KYC documents hadn't been provided, to the best of your knowledge?
I don't recall it. Maybe I'm not in the CC.
Okay, thank you. That's
Thank you very much, Ms. Thank you very much, Ms. Stewart. And I think now the first defendant will cross-examine this witness.
Thank you. Ms. Avyalova, you were taken to the email at 8-63, where you requested 4 documents. I don't know if you still have that open there. Your evidence in response to Ms. Stewart's question was that you asked for those documents to prepare the account opening agreement. That's right, isn't it?
Correct.
And it was by no means compliance with the due diligence requirements under the account opening agreement. That's right, isn't it?
In order to open an account, there are 2 steps. So first, these initial documents that go into the account opening agreement that needs to be signed to the clients, then they sign it. And then we ask the documents to do the full KYC.
Perfect. Thank you. And Ms. Avyalova, you were present, weren't you, at the 16th of December meeting with Mr. Turner?
Yes.
Can I ask you to turn up, please? Section 6-11. This is Mr. Al-Ali's witness statement. And in particular, paragraph 34.
Okay, let me read it.
Thank you.
This is regarding the meeting on the 16th, correct?
Yes. No, I'm sorry, there's an interference there somehow. It's been alleged, Ms. Avyalova, that Mr. Thurner made these representations set out in that paragraph. Can you just familiarise yourself with that paragraph, please?
Okay.
Now, as somebody who was present at the meeting, and Mr. Thurner has confirmed he did not make these representations, do you corroborate what Mr. Thurner is saying as to whether or not he made those representations?
Before that, I would like to state that HUOBI was first introduced by the buyer. So he never came to our office at first without the buyer.
Right.
And then, so when Mr. Al-Ali is stating this, he's already been in the meeting room with the buyer and TABARAK already. So I can state that Christian Turner didn't give any assurances as per this part.
Thank you. And then you were also present in the 3rd of February meeting, and it's been suggested that Mr. Thurner made or gave assurances in relation to the safety of the transaction, namely if the Bitcoin was transferred to the wallet. Mr. Thurner said he did not give those assurances. What do you say? Did he or did he not?
He did not.
I'm sorry, there's an interference there. I don't know.
Can Dubai boardroom please mute? There's a Dubai boardroom guest that's, I think, on.
Thanks, Mr. Matu. Right, that's better. Thank you, Mr. Matu. Can we turn to your witness statement, please? It's at 6-418. And I'm going to take you to 6-120.
Okay.
And paragraph in particular,
paragraph what? 10?
Paragraph 10 and 11. Would you like to just familiarise yourself with your paragraphs in that witness statement, please?
Yes, Ahmed. I couldn't hear the first part of your sentence.
Yes, I know there's some interference somewhere. I'm sorry about that.
If you speak a little nearer the microphone, we hear you better.
Is that me, Your Lordship, or Miss? Or
I can hear that. Can you hear that, Miss Avliova, when she's excuse me, when she speaks nearer the microphone?
Which
Try it.
paragraph?
So, paragraph 10 and paragraph 11, please.
Okay.
Yes?
Yes.
Now, Mrs. Avialova, you were present throughout the transaction on the 3rd of February, weren't you?
I was.
And there is nothing in your witness statement that talks about any conversation between Dr. Ahmadi, Mr. Turner, the claimants about any commission payment being agreed, is there?
In my witness statement, no.
So it's right, isn't it, that you were not present, in fact, when there was any conversation about any commission payment?
I remember a part, but it's been too long time ago. That's why I didn't put it.
Yes, and it's because it's been such a long time ago, you say that you can't be completely sure, which is why it's not in your witness statement. That's right, isn't it?
I am sure. If you ask me, I'll give you an honest answer.
Thank you, Ms. Avialova. I'm going to leave it there. Thank you, Your Lordship.
Okay, thank you. The re-examination.
My lord, you'll be very happy to know we have no questions. Thank you.
Well, Ms. Savliova, short and sweet, and thank you very much. You are released.
Honor.
Now, this concludes the evidential part of these proceedings. And now, it's understood by the parties that there will be written closing submissions. And what I'm going to suggest is this, that the parties in the next day or so seek to agree a timetable for when the first round of submissions come in and then the reply submissions. Now, I'm going to be reasonably indulgent about the time. This is a time of year with Christmas and holidays and so on intervening, yes. Which must be taken into account by the court. And I am prepared to accept an agreement which would look to know sometime in early to mid-February for the first round, and to allow a 2-week period thereafter for the second round. Luckily, we have a full verbatim transcript, and my impression of the witnesses is not going to fade. And accordingly, I think, as I say, I can take what in other circumstances might be an overindulgent attitude to the amount of time. So in the first instance, I'm leaving it to you to cooperate amongst yourselves and bear in mind what I've said. A reasonable period of time that goes into the early part of February is not going to find any protest from myself. But I want you to do this in the next couple of days so that I can confirm the timetable early on, so that that's put to bed and you know what timetable you're working to, no doubt, after the holiday.
Yes.
Your Lordship, just for the record, I think it will be the claimant's position. Well, it will be the claimant's position that we'd like to get the first round in in January rather than the first round in February. But hopefully we can agree that amongst council.
Well, of course, all parties want this matter to be resolved as quickly as possible. But this has been, this is packed with detail, this case. It's going to, the submissions are bound to involve a very careful scrutiny of the transcripts and so on. And I think with Christmas and New Year, I'd take some persuading, in the absence of an agreement between the three of you, that the submissions must be in by before the end of January. I've indicated that some time in early February would be fine, but let's see what you come up with by way of agreement. I mean, don't overdo reliance on my indulgence. See if you can abide by the broad parameters that I have indicated in coming to your agreement. If there's no agreement, well then that's be reported to me, and I will stipulate what the timetables to be. But I want to get this off the deck in the next 2 or 3 days.
Yes, and Your Lordship, on behalf of the first defendant, we certainly would be grateful for that time period, given the commitments, the holiday commitments and so forth. So we're certainly grateful for that indication of early to mid-February.
All right.
Your Lordship.
Yes, Mr. Matthew.
I was also going to seek your guidance on any page limit you might have for this closing submissions.
Well, I haven't been spared the amount of detail and particularly the amount of written submissions. Use your common sense. This is a case which is highly detailed, and I'm not expecting a 10 to 15 page closing submission. But you're not going to win any favors by putting in 50, 60, 70 pages. But I'm not going to set a limit. I trust you all to exercise some common sense. Right.
Thank you.
That's it. Thank you, counsel, all three of you, and for your solicitors for getting this trial underway. It's been a big matter. It's been involved a great deal of work on behalf of you and your teams to get it done. But there we are. The evidence is in the can.
And Your Lordship, we're grateful to you as well for your indulgence and your patience.
So I shall, of course, miss seeing you in the future, but I look forward to your written words. And on that note, I'll say goodbye. Thank you very much.
Before you go, are we, once we've filed written submissions, do we have an opportunity to speak to those by way of oral closing submissions, or is it just written and that's
just written?
Grateful. Thank you for that.
Okay. Goodbye.
Goodbye.
Goodbye. Thank you, my lord.